Deeply obliged. Obliged.
Item number 51 for delivery of order.
Two local sureties, 1 lakh.
Obliged, my lord.
Item number 52 for delivery of order.
Bail granted on two local sureties, 1 lakh.
Item 53 for delivery of order.
There are some conditions.
Conditions, my lord.
Bail granted on two local sureties, 1 lakh.
Unticked.
My lord, item
Yes.
number 28, my lord. It may come up along with item number 11, LA appeal number 11 of 23, my lord. This entire series, my lord, the similar matters are there.
Hmm.
It may come up after 2 weeks, my lord, along with 11 of 23.
Lordship, item number 27 and 29 is also lordship connected.
Yes, connected.
Yes.
Connected.
What may come up together, my lord.
He is appearing for-
27 and 29.
27,
the
28,
response.
29.
Right.
You are representing all.
I am
of them.
28, my lord. So
28.
entire matter may come up along with LA appeal number 11 of
London
23.
Senior Counsel, Mr. G.N. Sayala, with the consent of the other side, has prayed for adjournment, list the matter along with,
11 of 23.
when do you want?
Lordship,
After 2 weeks.
After 2 weeks.
fixing a date loss.
Huh?
Fixing the earlier of 2022 lordship.
Learned Counsel, Mr. J. Golita,
Lordship.
for the applicant.
Appellant in item number 27 and 29
27.
and respondent in 28.
It will go to 28 আসলে, it 27. With the consent of the others, 27, applicant come applicant, with the consent of the other side has prayed for adjournment, list the matter after 2 weeks, along with, LA number,
11 of 23.
LA appeal, 6 of 2022 and LAF 11 of
11 of 23.
11 of 2023. 29, Learned Counsel, Miss, you are for
S. Senapati.
item number,
Item numbers 27 and 29 for respondent number 2.
respond number, Learned Counsel, Miss S. Senapati, Government Advocate.
No, my lord, ONGs.
ONGC,
For ONGC.
Learned Counsel, Miss 29 of Likiba. S. Senapati for the respondent and Learned Counsel, Mr. J. Kodita for the appellant, stroke applicant are present. As agreed by both the sides, is the matter on after 2 weeks along with LAF number 6 of 2022, LAF number 8 of 2022, and LAF number 11 of 2023.
23.
What's the fixed date? After 2 weeks. lordship.
All the cases, dates, after 2 weeks, nala date at the after 2 weeks.
Lordship.
Okay.
Obliged.
May I please, your lordship? With due consent to the other side, my lord, I beg to item number 42, my lord.
Hmm.
Lord, I pray, my lord, 4 weeks time may be granted to file objection, my lord.
Item number 40.
2, my lord. I am for the opposite party in I, my lord.
A.K. Hussain,
My lord.
Learned Counsel, Mr. A.K. Hussain, with the consent of the other side, has prayed for adjournment, list the matter after
4 weeks. my lord.
4 weeks.
I plead your lordship. Lordship, I beg to mention item number 34. My lord, matter may be list after 2 weeks, my lord.
Learned Counsel, Miss
L. Wajida, my lord.
L.
Wajida.
Wajida, with the consent of the other side.
My lord, I am from him, my lord.
Huh?
I call him, but he is not received, my lord.
Wait for
What
the
is matter, my lord? I inform him, my lord.
Wait for him to come there
My lord.
for some time. Otherwise, then I will pass on order. if he does.
Wait, please, the lordship. Lordship, I beg to mention item number 18. The requisite application could not be filed as the petitioner is traveling. So the matter may be fixed after 3 weeks, lordship.
Learned Counsel Miss
P. Agarwala,
P. Agarwal on behalf of Learned Counsel Mr.
SP Roy.
S.P. Roy has prayed for adjournment, list the matter after 3 weeks.
Lordship, I wish to mention item number 8, Lordship. I may be allowed this petition. I may be allowed to do this petition. Lordship.
Withdraw.
Yes, Lordship. 8.
Learned Counsel Mr. S.
Along.
Alom has prayed for withdrawal of the petition. Learned additional briefing, Mr. D.P. Goswami is present. Petition is dismissed on withdrawal.
Liberty may be given. Lordship. I
With the liberty to file a fresh petition.
must.
I have list.
Hmm.
Lordship, with the consent of other side, I beg to mention item number 17, Lordship. The LCR has not been received, Lordship.
LCR has called for is not received. Learned Counsel Mr.
G. Boro
G. Boro on behalf
on behalf of RK Bhuya.
Learned Counsel Mr. R.K. Bhuya.
Yes, Lordship.
Item number 7.
17, 17.
Okay, 7. With the consent of the other side has prayed for adjournment, list the matter after
2 weeks.
2 weeks. All right.
May it please
Mm.
your lordship. Lordship, with regard to item number 7, my lord, I have filed one additional affidavit that may be called upon.
All right.
Much obliged.
Item 1.
May I please?
Hmm.
Lordship, here I have taken the plea of ground of arrest, Lordship, that is not communicated. Here petitioner was arrested on 3/9/2023.
We'll call for a CD.
Lordship, I provided
No,
already the certified copy of the.
No, we will need the CD. Call
Lordship,
for
that-
call for the scan.
Lordship, can you one aspect be considered, Lordship?
I'll give you a short day. We'll need the record. In the other cases also, both parties were heard elaborately. They were hearing for several dates. You're relying on 2-3 cases, no? Bobby Bukaster and Vihan Kumar.
Yes, yes.
Yes, those cases were heard.
Lordship,
Elaborate
because only one aspect, Lordship, because when the plea of ground of arrest is taken, other aspect may not be required, Lordship, because
Yeah.
it is specific in the behind clause.
you grounds of arrest, you have a ground. We'll call for the records within a short,
Okay,
call for the scan copies of the trial court record along with the scan copies of the CD, list and matter on.
okay.
Item 2.
May please, Lordship, matter may be taken after some time.
All right.
Item 3.
May please, second time there petition. Earlier rejected by your Lordship. Page 22, your Lordship.
Page 23.
22 is your losses order, your Lordship. Second time, this is
What is-
filed on the ground of medical
Circumstance.
ground, your Lordship.
What is the medical condition?
His physical condition not so good, your Lordship.
Medical certificate?
At page 26, your Lordship. Conducting doctor suggested him to take bed rest, your Lordship. At the below, advise bed rest after 15 days, avoid weight lifting. And otherwise, my lord, the affair is allegation is absolutely false allegation, your Lordship. Brought by the daughter-in-law of the petitioner, your Lordship, against him. Annexure 3, your Lordship, may kindly consider it.
The petitioner is a father-in-law of the victim.
My lord.
Let us call for a CD.
Lord,
Okay. Father-in-law of the victim. And this is bed rest for what? I don't know.
my
Doesn't
lord,
appear to
page,
be a very serious ailment.
my lord, page 9 may kindly consider.
No.
Eh,
No,
18, my.
no, not now. Very short date. From which Thana, very way?
Dubri.
Okay.
Call for the CD,
Agomani page,
call for the CD with the, along with the statement of the victim.
my lord.
List the matter on, do we?
29th May.
How much time?
29 May.
29. Will it come on 29 May? from
Akamai
Dhuri,
Dhuri.
CD. Today's,
Today's
one,
14th.
2 weeks.
2 weeks.
I think it will come, no? 29 May. Yeah.
Item 4.
Ablash.
May I please your lordship? My lord, it is a regular first appeal against the judgment and decree passed by the civil judge Bongaigaon. The appeal may be admitted.
Without issuing notice.
My lord, it is a first
Statutory
appeal.
appeal.
My lord, it is a
First
first
appeal,
appeal.
statutory appeal.
It is a first appeal. Is issuance of notice is not necessary.
Where is the ground of appeal?
Ground, my lord, I have page number 3.
This paper is loose. I don't know why. A paper can lose us. Hello. Hey, paper can lose us side bar. Why I get clear this? Page number 3.
3, 4, and 5. Partly declared.
Hard learned senior counsel,
Yes.
Mr.
AC Sharma.
AC Soma for the appellant. Uh, who has challenged the judgment and it passed by the learned civil judge senior division Bongaigaon in PS number 60 of 2015 on 4/11/2024. I have seen the memo of appeal. It appears that appeal lies against judgment and order impugned by the appellant. Bill is admitted. Issue notice to the respondents. Returnable within 4 weeks.
Yes. Records may be called for.
No, just a moment. Why is this I?
I for stay.
No, no limitation prayer
No, it is within
within
time.
the period of limitation. Appeal is also filed, is submitted that, is submitted that appeal is filed within the period of limitation. Call issue notice to the respondents, no?
Yes.
Respondents returnable within 4 weeks. As per usual process.
Yes.
Yes.
And the
Returnable meanwhile, call for the trial court records.
yes.
List according.
But then I have also filed a stay petition.
No.
I
That will I'll take up after.
Hello?
That I'll take up after at the time of order. Let the notice.
my lord, and notice may be issued on the stay petition.
Yes, that stay petition.
Yes.
Okay, stay petition not issue notice legally. I learned hard learned senior counsel for the applicant. Issue notice to the respondents, returnable within 4 weeks. This is according.
Yeah, there's a caveat, lordship, caveat has to be, lordship. You have
For the
it. You
caveat,
have served the copy, lordship.
We'll fix
No,
a
so
date,
to discharge
or
the
you
caveat.
want to place a submission
Lordship.
on admission, we'll fix a date or you'll.
Yes, my lord. No, lordship, it is it is first appeal, lordship, when I have an application for interim order, lordship.
I have objection in the interim order.
Yes, you will give his objection, lordship, let me complete.
Okay.
This is a regular first appeal, lordship, you have to admit, that's it. Lordship, what happened in this case, lordship, may please take up the IA 1492. Lordship. Lordship, the opposite party as plaintiff filed a suit along with an application for injunction. The learned trial court passed an interim order restraining my client not to interfere with the possession of the defendant, plaintiff. Well, no problem. Taking that interim order, Lordship, now he entered into my possession. He has demolished my wall. He has demolished everything. Now he has started construction. And the Supreme Court time and again say that it's a status quo type of thing, Lordship. You cannot enter into my possession. There is a restraining order that the defendant will not enter into the plaintiff position. Now, that does not mean that the plaintiff will enter into the defendant's position, Lordship. Lordship, may please come to page 83.
IA number?
IA number 1492.
Okay. Page 82.
Lordship, yes, yes. Lordship, it is started at page 79, Lordship. Annex 3. That's the injunction order in favor of the plaintiff expert. And Lordship will remember, this is an expertise order. My client was not there. They passed an expertise order. Then he said he has given here that the 39.3, no notice. I'll give the order. Now Lordship may come to page 83. Lordship, page 83, last paragraph. I have perused the case record and also considered the submission of the learned counsel for the petitioner. I have also gone through the relevant document annexed to the petition. After considering the materials on record, it appears that the petitioner has bona fide prima facie case to raise the apprehension against the opposite party who was disturbing the peaceful possession of the petitioner of the suit land. The existence of the registered sale deed and the reasonable grounds shown make it believable that the judicial action needs to be enforced so as to protect the right of the petitioner. In consideration of the urgency shown at this stage, an ex parte injunction need to be passed in the case by waiving the issuance of notice, exercising power under Order 39, Rule 3. Accordingly, opposite parties, their men, women, and agents are restrained from entering into the scheduled land and causing disturbance over the peaceful possession of the petitioner till further order. So, restraining the defendant, don't enter into the possession of the plaintiff. That's the order.
His land.
His land. All right, Lordship. Now, Lordship, he has fixed. Lordship can see it is an order of 27-1 at page 79, Annex 3. This order was passed on 27-1-25. And the next date is fixed on 17-3. Lordship, the CPC mandate. What time you can give? It is the next date, 17-3. All right, Lordship. There should be some limit of showing the EA, Lordship. Now we appeared in the suit on the date fixed. We filed our written statement. We filed our counterclaim. We filed the objection against the injunction, their injunction application, and we filed a fresh injunction application that look here, taking advantage of your injunction order, they have started all this. They have dispossessed me from my land and started construction. My wall is demolished. Now they have started their own wall. I have shown everything. I have shown clear photographs that the workers are there on the field. I have shown everything. Now, the same court, where the earlier he said that the 39-3, I am waiving everything and all that. Now, this time what happened, Lordship? The plaintiff counsel was there. We have filed our written statement, accepted. We have filed our counterclaim. They have taken the copy. We have filed our objection. They have taken the copy. We have filed our injunction application. They refuse to take the copy. Lordship, no, I am lucky, Lordship has come from the right. Every copy, we have filed the written statement, you have to give the copy. They are absecting. And that day, the plaintiff advocate was present. I personally argued the case. No objection, nothing against my argument. I have shown the Supreme Court judgment, I have shown the Guwahati High Court judgment. Only argument, one line argument, my lord, one line argument. I still remember our injunction order may be extended. That is the only line the learned counsel for the plaintiff has argued. Only one line. And I have shown everything. And the learned court, luckily, at least what I have argued, he has recorded. He has recorded what judgment I have shown of the Supreme Court as well as of the Guwahati High Court. Now he said, no, I cannot give this injunction without giving notice to the other side. So I have to give notice, then only after hearing both the parties I can get an injunction, because ex parte injunction I cannot give. How come it's an ex parte order? Earlier I am not there. You have given that. You said that the 39(3) there is an urgency. Now Lordship at page 85. Page 85, Annex 4 is my application under Order 39, Rule 1 and 2, Section 94 and Section 151. Lordship get it. Now Lordship at page 91. Page 91, paragraph 9, 10. Specific statement, Lordship, on oath. That thereafter, after the injunction order, Lordship, what happened? That thereafter on 21/11, the opposite party illegally and forcefully encroached upon the entire scheduled call land and dispossessed the petitioner from the scheduled call land. The opposite party has started construction of a boundary wall, including the scheduled call land. The petitioner submitted an application on 24/12/24 before the Circle Officer, Sipazar Revenue Circle, informing the forceful enforcement by the opposite party and requested to restore the possession of the petitioner. 10. That the Circle Officer, Sipazar Revenue Circle, by letter dated so-and-so, informed the petitioner that on 8/1/25, in connection of demarcation case number so-and-so, they went to the scheduled call land, and after spot verification and measurement, it was found that the scheduled call land has been under possession of the opposite party. Since on the date the opposite party was not present, the Latmandal reported that the demarcation case could not be settled. Specific. Now the paragraph. In fact, in the northern side of the newly constructed northern boundary wall, the opposite party has laid this LS 3 bigger 10 lesses of land, having breadth of 28 feet, one road of 28 feet. Now they have constructed. Now, Lordship, this is my application on what I have stated everything. So, Lordship, may please come to page 97. Para 20.
Okay.
Page 97. That the matter is very urgent and the guise of passing the ex parte administrative order, the court in Mizze case number so-and-so on 27/1/25, thereby restraining the opposite party during petitioner hearing from entering into the scheduled land and causing disturbance over the peaceful possession of the petitioner therein. The opposite party in carrying out construction work in scheduled call land at war footing. The enforcement has been asserted by letter dated 13/1/25, wrote to the petitioner by the Circle Officer, Sipazar Revenue Circle, and said restraint order is immediately needed to preserve the scheduled call land during the adjudication in trial by waiving the notice under Order 39, Rule 3 CPC. I have specifically made statement. Now, court passed the order at page 101.
This is the impugned order.
Lordship. This is the impugned order.
All right.
Page 101. Lordship started with at page 102. This Mizze case has been arising out of petition number so-and-so, so-and-so. The petitioner is represented by the engaged learned counsel heard learned counsel appearing for the petitioner counterclaimant. Lordship, he is silent that the advocates for the plaintiff was present there. Not even mentioned in the order. Also, I have taken the certified copy that they have appeared in the case. They have, and in the other all title suit and the injunction application, he has passed the order. I have heard the other side. I have heard everything. This case, he said, no.
They have not accepted the notice.
Lordship, they have to. That is the CPC, Lordship. Order 3, Rule 3, once the advocate appeared, whom to I will give the copy. This is the ribbon they did. Order 3, Rule 3 is very clear. Rule 5. So that is how he started. And what he do, Lordship? Page 104. In fact, what I have stated before, Lordship, he has written everything from 102. That my argument he has written, Lordship, everything, 102, 103, 104, he has written everything, that they have dispossessed me, they have started construction, he has written everything. Then he has also quoted, the learned counsel for the petitioner has relied upon the judgment of 1994 2 GLR page 104 and 1983 4 SCC page 31. Though I have shown two other decisions, all right, Lordship, at least 2 judgments he has referred. I have shown 4 judgments, but the 2 judgments he has referred. Now, Lordship, at page 104, I have perused the case record along with the Mizze case number so-and-so and also considered the submission of the learned counsel for the petitioner. After going through, Lordship, I am reading at page 104. Lordship, get it now?
Yes, yes.
So, Lordship, here, Lordship, pausing for a moment, Lordship. Lordship is very correct that they have not accepted the copy and all that. They will take that. Very good. Now, what he has said, I have perused the case record along with the Mizze case number 14 of 2025. Yeah. Whose Miss case? Their Miss case. Injunction. So he has read both for this purpose, for rejecting my application, my ad interim, and also considered the submission of the learned counsel for the petitioner. After going through the fact of the case record as well as the submission of the learned counsel for the petitioner, it is apparent that the passing of an ex parte injunction will not be proper at this stage, which requires proper adjudication. So, aspect of the ad interim temporary injunction is not taken into consideration at this stage. On such perusal hearing so-and-so, now he has fixed 3/5/25. 3/5/25 years in leave. For what? And for what for this date was fixed, thus you will see for a moment. 3/5/25 for SRN objection, not objection. Already advocate appeared, everyone is there. So this is this type of order. Now the next page, Lordship, 106. For the other cases, he is considering their appearance, Lordship, in all other order. Both sides are represented. Opposite party number 1 has submitted their file written statement. Opposite party number.
Today they are here, so what is the problem?
Lordship, I'll show just 2 documents, Lordship. Just 2 documents. Lordship, 117. Page 117. On my application, Lordship, the circle officer went to the plot, given this report. It's an official report, Lordship. It is regarding 27 of Gusaro Nokol copy Homporken. Ukto Matir Zukmak Kuri দেখা যায় যে উক্ত মাটির আধা অংশ ঈশ্বরচন সিনহা দখলত থাকা দেখা যায়। উক্ত দিনা ঈশ্বরচন সিনহা অনুপস্থিত থকাৰ বাবে সীমা বিবাদৰ মীমাংসা নহল বুলি লাটমণ্ডলৰ প্ৰতিবেদনত জনা যায়। He is the plaintiff. Lordship, the next page, 118. not even black and white. It's in color film, Lordship, nowadays. My land started construction of wall. My all year it is demolished. Next page, 119. Then started construction of house on my land. If this case someone will not protect, in what case this court will protect, my lord? 21 lakhs, paying 21 lakhs, I have paid, I purchased this land. It is in my possession, Lordship. There is mutation in my name. Everything is in my favor. Then, Lordship, they see the house over the year, page 121 and 122. And nowadays it is GPS photographs, Lordship. Date and time and everything is there.
Yeah.
So this is, Lordship, I will only one line from 1993, 3 SCC, Lordship. Long back court thought that this type of thing happened. 1993, 3 SCC, page 161. That's Shiv Kumar Sadda. I will not read everything, Lordship. Lordship, may please come to page 177. Page 177, Lordship. The last line. Ex parte injunction are cases, real urgency, where there has been a true impossibility of given notice of motion. An ex parte injunction should generally be until the certain, usually the next motion day. In our case, Lordship said it was extended and extended. Now, Lordship come to 36, para 36, accordingly, 1, 2, 3. Lordship in the Roman 2, last line.
Yes.
If the corporation entered into appearance, any such ex parte order of injunction should be extended only after hearing the counsel for the corporation. If on that day, he has extended the injunction order, why he is not hearing me? No copy, Lordship. Let them show that they have served the copy on me for extension. No hearing on the extension. We have filed our objection, everything complete. My pleading. I have given the photographs, I have given everything, I have given my mutation, everything. All the document I have given a bunch of paper, Lordship, not 1, 2 papers, Lordship. This bunch of paper I have given before the court, before the trial court. It is total 128-page document I have given before the trial court that I am in possession, Lordship. Now, Lordship, the last line, 178. While passing an ex parte order of injunction, the court shall direct the plaintiff. Lordship will take note of this. One should be very careful, Lordship, nowadays. While passing an at page 178, Lordship.
Yes.
Roman 3. While passing an ex parte order of injunction, the court shall direct the plaintiff to give an undertaking that he will not make any further construction upon the premises till the application for injunction is finally heard and disposed of. I am on that thought. Nothing else. No one can do this. 1983 Supreme Court, long back Supreme Court has said that it is, Lordship, the 1983 4 SCC page 31, para 6. Para 6, Lordship. Addition, copy. Page 33. We are satisfied, having given the matter our anxious consideration, we are satisfied that it is not a case in which the interim injunction could be refused. Similarly, you are of the opinion that the respondents are allowed to put up construction by the use of FSI for the whole of the land, including the land involved in dispute. The situation may become irreversible by the time the dispute is decided. I am on that, Lordship. This is para 6, Lordship.
Which part?
Last 4 lines, Lordship. I have read, Lordship.
Last 4 lines.
Last para 6, page 33, Lordship,
Page 33.
from middle. Having given the matter our anxious consideration, Lordship, get it?
Yes.
having given the matter of anxious consideration, was satisfied that this is not a case in which interim injunction could be refused. Similarly, we are of the opinion that if the respondents are allowed to put up construction by the use of FSI for the whole of the land, including the land involved in the dispute, the situation may become irreversible by the time dispute is decided and would preclude fair and just decision of the matter. I am on that, Lordship. And this is my case, Lordship. Before the trial court also, and Lordship, now the date was fixed on the long date, and the last date, Lordship, I'll give a copy. And that too again for put up. So where I'll go, Lordship?
Construction is going on.
Construction, I have given, laborers are working, the end 24 hours construction, Lordship. For put up, let's say, after 1 week. So I have to wait, let them complete the construction, then my client will go somewhere.
They have surfaced the material fact, my lord. They have not come notice on our court with clean hand, my lord. Because earlier injunction order granting the plaintiff, my lord, in favor of plaintiff, but they violated the injunction order, my lord. That is why a petition was filed before the landed trial court, my lord. That is why their conduct is not proper and taking into consideration, my lord, the landed trial court has not contained the interim injunction order, my lord. And their allegation is that you are, both parties are heard. That is false, my lord. Because in our absence, they moved the petition, my lord. That is why the landed trial court.
But you were present on that day.
No, my lord. We are present in the first half. When our completion of the argument and all other proceeding, when it come back, then they moved the petition. That is why landed trial court, my lord, passed this order. To
But
start
you
the
see,
the injunction violation
Yes,
order.
Madam, for a moment, in this case at least, I personally appeared there, and the only one lady advocate appeared. He said nobody has come from Guwahati today, so Lordship will adjourn the matter and extend our injunction order. That is the one line, argued. And Lordship, I personally appeared as a member of the bar. I said he was not there, and my petition, Lordship can check the time. I was there in the court. Lordship can call for the CCTV PA, Lordship. I'm there. If he was there in the court, Lordship can call the CCTV report there from the
Violation of
court.
Injunction order.
No, Lordship, there has to be some limit, Lordship. Saying
Violation
false.
injunction order,
Making
or
false
there is
statement,
violation, my lord, under injunction order, my lord. That is why the learned court also directed the police to consider the case, and police also filed a report, my lord. And they stated that no petition for extension or interim order, my lord, filed. They, on their petition, they have filed objection in the interim order, miss case, my lord. And in their presence, my lord, interim order was extended, my lord. And the, my lord, the petition filed under interim injunction is a discretionary power of the landed trial court. Landed trial court has, that is why rightly passed the order, my lord. There is no error. Sir, hearing the both sides, the landed trial court will pass the order. Because of their conduct, they violated the injunction order, my lord. For the petitioner, the plaintiff filed their petition for protection.
okay, it's okay, okay.
My lord.
Maybe
That
they
is
have
why their
violated
conduct is
the,
not, they have not come
it's okay,
to the
okay,
court.
they have, maybe they have violated injunction order,
Fine.
but you see, their allegation is you're constructing. That,
Constructing, in my land, my lord, I am constructing, my lord. I especially admitted in my lord, in my land, my lord.
so now
Land
if
is
it will
defined,
be
lord.
stayed, will there be any problem?
My lord.
If your construction will be stayed for some time till the next day. Why do you want to complete the construction? If it is over your land,
So then maybe we will,
short date, yes.
my lord. it was-
Stay for short date.
So after lordship may hear.
See,
it can
the
make
land
up
is in
within
dispute,
10
I
days, my
think.
lord.
You are saying that you have constructed over your land. He is saying that you have constructed over their land. So land is in dispute. So why don't you maintain status
They are
quo?
not claiming our land, my lord. Schedule is different, my lord. My land is different, their land is different, my lord. I am constructing my land. Land E and F, my lord. Their schedule is co-schedule, my lord. Their patta number also different. Village in the same, my lord. That is my problem.
No, I'm not going into all those whose land.
Right.
Whether it is your land or whether it is his land, but you can stay the construction for a bit. When maintain
I'm doing
status
my-
quo.
From 2024, before filing the suit, my lord, I am doing my construction in my land. My 14 bigha of land. They are illegally entered and are try to take possession of the plaintiff's land. That is a right title clouded, my lord. That is a approach before the trial court. Trial court, after hearing gravity of the my lord situation, passed the interim of directing defendant not to restrain the plaintiff, my lord. It is, my lord, an interim injunction. They can, this is not final order, my lord. Immediately the landed trial court will.
After construction,
would appear with-
then there'll be question of demolition also. If you are, you cannot prove your case,
Yes, ma'am.
there'll be question of demolition also.
Your lordship may direct the landed trial court to finish the entire matter of the within 10-15 days, my lord. Then we will join in, my lord. Only their grievances there, they are at interim.
I have no problem, my lord. Let it be sent back. But
Yes,
in
my
the
lord.
meantime,
It is
status
right.
quo be maintained. No one should construct. No construction. Yes, he is very correct. Let the matter be sent back. 10 days, 15 days, 7 days, I have no problem. But the maintain status quo. Don't construct. Heaven will not fall down, my lord. This is someone's land you will enclose and this third construction. I have given photograph, my lord. Nowadays it is GPS photograph, lordship. Lordship will get the date, time, everything. And there is a circle officer report that they have enclosed my land.
We also.
And then lordship, they direct the trial court to send the Amin commission before hearing. Things will come out, whether it is my land or their land, lordship. 26(9) is very clear. It is court can send Amin commission. Nobody have to file application. Order 26, rule 9, the first line itself is very clear.
Can be sent, but trial court will decide.
Yes, sir,
During
trial
Amin
court will
commission,
decide in
trial
the
court will
meantime
decide.
status quo, lordship, that's all. Yes, I have no problem, any date. 7 days, 15 days, any date, lordship. Any date.
The entire, this application is for.
Yes, yes, lordship can dispose of the first appeal, lordship can dispose of the interim the application.
Appeal against order.
Yes, lordship maintains status quo,
Dispose of-
trial court will decide on a particular date, till then status quo. But no hanky-panky lordship, they are going there for SR, then for A, then for put up, all this will not do. Because only one court, I cannot say send it to some other court also. Only one court, my lord. And I have seen what the plaintiff is doing, entering into the court. I will not say anything against my learned friend because he was not there. He was not there. So I have seen everything. If someone will go and see the CCTV, lordship will got everything. What happened that day? What I have argued, what I have argued, what I have argued, what the plaintiff counsel will argue.
That is
Hey, all right, I will see. Lordship can see the any one line
They
from
have
the
to
order,
challenge the
that
interim order, my lord.
anything
They
from
have
the order.
themselves violated the interim order, my lord. That is why, my lord, the landed trial court, taking into conduct and consider their conduct, did not grant the, my lord, interim order.
Lordship can see the order. If that is there,
So which matter should I take up, the application or the FAO?
FO, lordship can dispose of both.
Together.
Both, lordship can dispose of both, send it back, that they have heard and the date may be fixed. And no further time, lordship, that's all. Because they are doing all this, SRN objection, then put up on the date the learned judge was on leave.
Both
All
parties
this.
appeared on the email.
Yes.
But
And in the meantime, status.
SR is not necessary. Now you are here
yes, ma'am.
with that matters.
Yes.
SR is not necessary.
But
What
no
is
status
the
for-
point, lordship?
Practice
On
was-
that day also they were there.
I am in my land.
In all other cases, lordship, order is there. They filed Hazira lordship, I can show.
Yes, we file Hajira in our cases, my title suit, but not in your cases, your lordship.
Oh, now we have to file Hazira in
In our
one
case,
case
they
and
want
one
to
case
move
and
this
one case.
order.
Okay, okay, title.
Why
suit
the
and-
learned transport with them?
We are learning, man. Learning, man.
Higher it will be clear.
Not like that.
Third learner senior counsel, Mr. S. Sharma. Order. Appellant. Saroj Verma. And learner counsel, Mr. For the aviator,
Yes, sorry, Kemal.
S. Soikia.
Aye.
For the caveator,
Okay,
respondent, Ishwar Chandra
the
Singh.
sole respondent here.
For the respondent, for the sole respondent, Ishwar Chandra Singh. The appellant is aggrieved by the order dated 17/3/2000. Okay, 17/3/2025. No, this is your order.
Lordship,
17/3/2025 passed by the learned civil judge senior revision in connection with Miss J number 30 of 2029 arising out of TS number 12 of 2025. It is submitted that an ex parte injunction order was passed against the applicant stroke appellant
on 27/1/25. Page 79.
on 27/1/2025 in connection with the same case, no?
Same,
Miss-
no, Miss J case is 14 of 20.
Miss J number 14 of 2025 arising out of the same title suit number TS 12 of 2025. এইটো ex parte injunction order was passed to the আগৰটো correct এইটো কাটি দিয়া এইটো হেৰি দিছিলো যে 17/3/2025 ex parte injunction order was passed বুলি লিখিছিলো না সেইটো কাটি দিয়া খালি aggrieved by the order dated 17/3/2025. Here your injunction order was rejected.
Yes. In my application 39 of
Ex parte
20.
injunction order was granted বুলি লিখিছিল যে এইটো কাটি দিয়া It is averred that by the order dated 27/1/2025, the learned trial court passed an ex parte injunction order
Page 83, Lordship, last line. Accordingly, the opposite party there. Page 83.
last line, no?
Yes, my.
Directing the applicant directing the appellant appellant, their men, women and agents and restraining them from entering into the land mentioned in the schedule of the plaint.
Yes,
All right.
yes,
Yes,
One schedule only in the plaint, no?
yes.
plain in my lord, E and F, my lord.
Which one?
Plain
This is not, then not mentioned, Lordship, in the order. Not
Okay.
mentioned. What is there in the order, Lordship?
Mention in the schedule, mention in the
Schedule of the plan.
disputed land लिख दिया. Mentioned in the disputed land. No, mentioned.
In the scheduled land.
Mentioned
it
in the
is there.
schedule of the plan ना लगे. Mentioned in the scheduled land
Yes,
in dispute. Scheduled land in dispute. And restraining them from causing disturbance over the peaceful possession of the present respondents who are the original plaintiffs, who are the plaintiffs in the original title suit. Full stop. The appellant is aggrieved by the impugned order as the respondents have constructed a wall by demolishing the appellant's wall and have encroached into the appellant's land, and thereafter they have constructed a building.
We have started the building and
And
the
they have
wall.
started constructing a building along with wall. Annexure 9.
Annexure lordship, the last annexure lordship, from annexure 9 collie. This is the photograph lot. From 118, page 118.
Annexure 9 of the IAC 1492 are the pictures relating to the construction works carried out by the appellants. Oh, no.
Respondent plaintiff.
Respondents stroke plaintiff over the appellant's land. It is submitted that the case was fixed for 3/5/2025, and on that day the learned trial court was on leave. Thereafter, this case has been fixed on when for put up
27/5.
20.
They order to Nidhi.
This 28/5.
Yes, Lord.
This case has been
For put up only.
fixed on 28/5/2025 for put up. So it is further submitted that meanwhile the construction may be completed, and this will result and this will cause irreparable damage to the plaintiff or to the appellant's right, title, and interest. Full stop. Against this illegal construction, the appellant preferred the Ms. J case number
39 of 2025, page 102.
of 2025 and prayed for an injunction, order to restrain the respondents from entering into the property and from further construction over and from further illegal construction over the suit land. Full stop. It is further submitted that on that was date 17/3,
Lordship.
17/3.
Yes.
On 17/3/2025, both the parties were present, but the respondents have refused to accept notice in connection with the aforementioned Ms. J case number 39 of 2025. Despite the fact that the respondents were heard in the
Title suit as well as Ms. J case number 14. That is at page 106.
in the same title suit, TS number 12 of 2025, along with the Ms. J case number 14 of 2025.
Wherein their injunction order is extended.
It is submitted that in the corresponding Ms. J case number 14 of 2025, the injunction order of the respondents
Plaintiff.
in injunction order in favor of the plaintiff stroke respondents was extended by the learned trial court, whereas in the corresponding Ms. J case number 39 of 2025, no injunction order, not even a status quo order, was granted in favor of the applicant to restrain the appellant respondents from such illegal construction as mentioned, as aforementioned. Learned, I have heard learned additional learned counsel for the respondents stroke plaintiff who has raised serious objections stating that the appellants have not come with clean hands, post up they have violated injunction order which was in favor of the plaintiff stroke respondents. Post up it is submitted that appellants have suppressed material facts. The learned counsel for the respondents has raised serious objection against the what is your objection relating to which part of the prayer?
Mainly, my lord. Getting the injunction order, ex parte injunction order.
Serious objection against
Ex parte. hearing.
against the prayer for injunction against the prayer of the appellants for prayer for an order of injunction to restrain the plaintiff stroke respondents from entering into the suit land in connection with Miss J case number, yours is 39, no?
Mine is 30.
Miss J case number 39 of 2025.
Whatever objection and ye they will file, Lordship will fix it. In the meantime, they will file objection, give us the copy. Because on that day, they will go, they will say, we will file objection, we will given time, not that. Lordship fix a date, fixed date. Before that, they will complete all pleading.
It is submitted that the respondents may be allowed to file their objection in connection with the aforementioned Ms. J case number 39 of 2025. I have taken a pragmatic view. It appears that as the respondents have appeared in connection with this case, their appearance is indeed complete in relation to Ms. J case number 39 of 2025.
Yes.
So this so now the respondents are hereby directed to appear before the learned trial court. When? Within 2 weeks? I'll give you date. Or 3 weeks. Do you want 3 weeks? 2 weeks. Okay. On 2 weeks of date of the area. On 29th of May. And file their objection and whatever. Anything else?
Objection and the objection, then on that day,
And
court will
file
take the
their
objection.
objection and place their objection. In terms of the.
And Lordship, then we fix the date for hearing, objection hearing, we have to complete the, Lordship. At
Objection
least 7
hearing
days
also.
up thereafter.
After they will file the objection, why should I fix the date?
No, then that day, Lordship,
Trial court will fix
no,
the
no,
date.
then that day matter will be disposed of, Lordship, this injunction. Otherwise, again, the same thing will happen. Put up, SR, all these things will go
Okay,
on.
okay. Till then, both the parties are directed to maintain status quo over the disputed property. So this is there. So till then, they will place their objection.
Till the matter or this Ms. J case number 39 of 25 is disposed of, no
The
further.
learned trial court is also directed to make every endeavor to dispose of the Ms. J case number 39 of 2025, no?
Yes.
Within 3 weeks. Huh?
Along with their Ms. J case also, Lordship.
Huh?
Both the Ms. case have to dispose of.
No.
No.
The other also you want. You have
No,
come
no.
against one case only.
No. How the other case will, Lordship? There is an injunction that will continue then. There is an injunction against me.
Okay. That's it. But you have come against one case.
No.
Both the cases.
Yes. My point is, Lordship.
Because your petition is voluminous, so I haven't gone to the.
No,
case.
Lordship will see.
Against the
Both the
agreement
Ms.
is the
J.
order passed against his order, my lord, 39, my lord, in not 14, my lord. 14, Miss case 14, if he is approached before discovery.
So their order be continued, Lordship, against me and them.
I'll just go through the prayer portion only. If there is a prayer, then I will pass the order. If there's no
No
prayer,
prayer for.
then I will not pass
my
the
lord.
order.
Yes, my lord. Yes. Only come against the 39, my lord, non 14, my lord. if he filed 14 against the 14, that was not maintainable, my lord.
So 14 be there. My,
Then I had to argue, my lord, their petition is not maintainable, my
okay,
lord. Again, if he
Lordship,
come against 14, my lord.
that may be recorded, Lordship. His argument should be recorded. Lordship.
Just a moment.
So, lordship may peruse the cost title, the main, FA, my lord. Mains, my lord. Order 4301 against the orders 17,325.
17.3, no? Order dated 17.3 is at which
17,3,
page?
my lord. 17,3, 2025.
At which page? Order dated 17.3. No. Only one prayer only.
So their injunction will continue, my lord.
That I won't say anything because this is this entire appeal is relating to only one prayer. This is 17.3, 2025, only one.
No, Lordship, Lordship will hear me. There is an injunction order. Against that, we have filed our objection already. So that will pending.
An appeal, see, this is your appeal.
Yeah, I know, Lordship. My appeal is rejecting my prayer.
Yes.
Now, Lordship is sending it back to hear my matter, my injunction matter. Now, already there is an injunction. Pleading complete. That will not be here.
That will be heard.
Yes, that is what I'm saying.
But that order I cannot pass here.
No,
in this
along with,
case.
no, Lordship will say that the whole, both the injunction matter be heard together. 151, Lordship.
No, you see, you do not have any prayer or
No,
particular pleading.
no, I have come against 17, Lordship. So that is why, but I have annexed that. That is, there is an order. I have filed objection, pleading complete. Both will be heard together. Both the music cases.
I'll have to ponder over it.
Lordship, then Lordship may admit and keep it the matter like this. Lordship, there I do not know. There is no point, Lordship, going there because their injunction will be continued. And Lordship, I am going to here to argue one matter. Lordship will admit the first appeal.
Now, I'm not very
We'll try
clear.
our
I
luck,
have to
Lordship.
ponder over it.
Lordship admit the first appeal. In the meantime, to maintain status quo, Lordship. We'll argue the matter, whole matter, Lordship.
Okay, then.
Yes, only.
Or else I can pass an order.
Yes, lordship may pass out.
You'll appear in the other case also then.
Their case, Lordship.
I can make a direction to, because you see, if you raise objection, then I'll have to ponder over it. That Miss J matter.
Right.
An order can be passed.
Right.
There's no hard and fast rule.
Right.
An order can be passed
Right.
to dispose both the cases together.
Right.
14 also?
My lord, my lord.
Okay.
That may be.
All right then.
Yes, Lordship.
Every endeavor to dispose the analogous injunction matter also.
Right.
No, to dispose of this matter, it would 39 RO and the analogous injunction case. What is the injunction number?
14, my
Miss J
lord.
case number?
In Miss J case number 14, page 79.
14 of, even then I'll just ponder over it later. I may not change.
Lordship,
Without hearing you, I'll definitely not change. But I'll have to ponder over it.
Lordship do not want to do
I will
anything.
fix the case for orders.
Lordship can keep the matter. Lordship the first appeal admit.
No, there he is allowing then. He's
Then okay,
agreed.
then
then.
Lordship can send it back. Otherwise, there is no point, Lordship. Their Miss J case will continue and my Miss J case.
See, I'm keeping it open. If in case I don't feel like taking up and directing to pass orders in both the cases together, then I'll.
He has agreed,
My
Lordship.
lord.
He
I
has
leave
agreed.
it up to your lordship. Lordship may peruse the entire record.
Okay. It is 14 of 2025, no?
Yes.
Within 3 weeks. within 3 weeks, make every year to dispose of the both the cases relating to the order of injunction arising out of title suit number 12, what is the title suit number?
12 of 25.
2000, arising out of title suit number 12 of 2025 within 3 weeks from today.
In the meantime, both the parties will maintain status.
No, that I have passed, that order I have passed.
Yeah.
অকমান মই হেৰি কৰি দিবা মই পাছত কাৰেকশ্যন কৰি দিম যদি অলপ কনফিউজন হয় মোক কৰি দিবা মোক।
Lordship, in the trial court, date is fixed on 28 and Lordship is fixed on
No,
29.
that I have said, no, it will, that matter will be.
So we'll go on 29, Lordship. Now it is the trial court, Lordship has date the fixed on
That is for
28.
put up.
Put up. So
Nothing will
Lordship is
happen.
fixed at 29 for final hearing.
For hearing or
Yes, both
for
sides.
placing their objection. I have fixed the date for placing the objection and to make every endeavor to dispose of both the cases after 3 weeks.
Till disposal,
Mid cases.
till disposal status.
That I have passed.
Yes, sir.
কিবা লাগিলে মই হেৰি কৰি দিম।
Huh?
একেলগে লিখিছে। একেলগে।
Lordship can dispose of the affair.
Together, I'll pass the order together.
Lordship.
Item number 6.
May I please, your lordship?
Yes, yes.
It's an regular appeal, your lordship, against the judgment passed by the learned trial court, whereby my suit was decreed partly. Against the remaining part, I have come before this honorable court. And there is no stay prayer. It is a regular first appeal. Your lordship may admit. If your lordship like to hear facts, I can say
No stay, no?
nothing. It is regular appeal. Against that,
No, there is no prayer for stay or anything?
nothing left. No interim prayer.
All right. Third learned counsel, Mr. B.K. Jain, for the appellants who have filed this, who have preferred this appeal against the judgment and order dated
Page number 2, 28/11/2024.
28/11/2024 in connection with
Title suit number 271/15.
passed by the learned civil judge senior division number 2 Kamrup Metro in connection with TS number 271 of 2025.
Only against.
Huh?
Yes, Lord.
Peruse the appeal memo. The respondents are Green Square, RE and Infrastructures and Nalai respondents. It appears that appeal lies against the impugned judgment and order. Appellant appeal is admitted. The appellant to take steps to issue notice to the respondents returnable within 4 weeks. Please accordingly.
An appeal is only on that part of the, because my appeal was, my suit was partly allowed.
Hmm.
It was only against that part of the judgment whereby though specific performance was allowed, but the compensation and interest was not allowed. Only that part I have got. It is on page 2, title I have given.
You want me to mention all this?
All this. It is page 2, it is mentioned, your lordship. Judgment and decree dated 20 at the top.
The appeal is preferred partly only against that part of the judgment and decree dated.
Whereby the
Which
claim,
page? Which page?
page number 2, lordship. Top.
Whereby the claim for compensation was rejected and interest part was not discussed.
At all.
Only that much. Okay, you could have preferred a review.
No, lordship, it was rejection total altogether. If not considered, that amounts to refusal, your lordship. Lordship, the records may be called for
Meanwhile, call for the trial
Yes,
court
sir.
records.
and notice may be issued.
Notice have been issued.
Before your lordship is in custody since 18/5/2022, my lord. It is, my lord, as on today, my lord, he has completed 2 years, 11 months, my lord,
Mm.
as 27 days. that is 1092 days. And there are, my lord, 11 numbers of witnesses. Only 5 could have been examined, my lord, till date by the prosecution. So that is another, my lord, ground where I'm seeking my lord's consideration for release of my conditional liberty on the grounds of prolonged incarceration, my lord. And 2 additional affidavit, my lord, which is brought on record today. I have also raised, my lord, the issues regarding non-compliance of, my lord, section 50 CRPC, as well as all the relevant documents, my lord, I have placed before this honorable court. And these are also in record, my lord. Yes. So Lordship, kindly consider these 2 aspects, my lord. I have already completed. 1 is prolonged incarceration, my lord. And only 5 witnesses, my lord, out of 11 has been
What
examined.
is the contraband?
Contraband was, my lord, it was from waste material, my lord. But truck was loaded with waste material. From there, my lord, 1,183 kgs of ganjas recovered, my lord. About this waste material, my lord. Waste cartoons, as per the prosecution case, my lord.
1,000?
183 kgs of ganjas, my lord.
That notice section 50, have you seen?
Yes, I have seen and technological. And source it submitted on
So how is it cryptic or cryptic?
fifty. And
Only my-
other materials are, I mean, okay, source it submitted 29/7/22 and source framed on 5/11/22. PW 1 examination 31/3/23, PW 2 on 19/7/23 and PW 3
Charge was framed on
5/11/2022.
5, 1,000 kilos of
Yes, my
ganja.
lord. 11, 12,
Where is the judgment?
my lord, one is Praveed Purkasto, which I'll just give. And Lordship, another very recent judgment, Lordship has considered, my lord, where this quantity was recovered, but because there is a prolonged, my lord, delay in trial. So Lordship was pleased to release him with some stringent condition. May I just place this order, my lord. And take the details, my lord. Sentence.
নতুন নেকি নতুন পিটিশন পাৰিবা কি নাম তোমাৰ and where is the probate protest
Yes,
case?
my lord, yeah, I'm handing over, my lord.
Paragraph
Paragraph 19 is relevant, my lord.
paragraph 19.
Yes, paragraph 19 is 19, 20 and 21 are relevant, my lord.
No, no.
Where 19 is very relevant.
Only one paragraph.
19.
He is new.
19 and 48, my lord. These 2 paragraphs are relevant.
19 and 48, 2 paragraphs.
Yes, my lord. Yes, 2 paragraphs only. So with any stringent condition, Lordship, I take the trial, my lord.
Out of 11, 5 PWs are already examined. 6 yet to be examined.
Okay, I'll grant bail. Third learned counsel, Mr.
M.A. Chaudhary.
M.A. Chaudhary for the petitioner Wasim. Huh?
Yes, my lord.
Wasim, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 18/5/2022 in connection with special NDPS case number 78/2022 arising out of so-and-so PS case under so-and-so sections. It is submitted on behalf of the petitioner that the petitioner has been behind bars for 2 years, 11 months, 27 days. And only 5 out of 11 witnesses have been examined so far. The petitioner's full stop. The petitioner's right to personal liberty has been curtailed due to the procrastination of trial, by the court as well as by the state. The petitioner has also filed an additional affidavit and has brought up the argument that the grounds of arrest have not been communicated to the petitioner in a language understood by the petitioner. On that score alone, the petitioner is entitled to bail as his right to personal liberty has been curtailed. The petitioner has relied on the decision of the Honorable Supreme Court in Probate Pukasto versus state within bracket NCT of Delhi bracket close reported in 2024 within bracket day too. 8 SCC 254, wherein it has been held that
Yeah.
paragraph 48.
98, 19 and 19, my lord, the written grounds has to be communicated, and 48, my lord, that.
19
Karan.
and 48, huh? It was a paragraph উঠাই দিবি। The learned additional PC has raised serious objections stating that the petitioner is booked under a heinous offense and the length of detention is not a criteria to grant bail. Full stop. The petitioner was caught transporting, was apprehended, apprehending apprehended, transporting 1183 kgs of ganja in the garbo, transporting waste material
Yes, ma'am.
through the truck. Full stop. Charges were framed on 5/11/2022 and trial is proceeding at a regular pace. Full stop. This is not a case where trial has been procrastinated. I have considered the submissions at the bar with circumspection. I have also scrutinized the trial court records. The petitioner is indeed booked in a heinous offense, but the petitioner deserves bail as the grounds of arrest have not been communicated to the petitioner in a language understood by the petitioner. In the light of the decision of the Honorable Supreme Court in Provi Bukastov's case Supra, it appears that bail may be granted to the petitioner. The petitioner is hereby enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which he is alleged. Next, the petitioner shall not leave the jurisdiction of the court. He is from that place, no?
No, no, my lord, he is from outside the state, he will not leave the jurisdiction, lordship will put this condition, my lord.
Where will he stay?
Lordship,
Where will he stay? If he's from outside the state,
no, my lord, since, my lord, they have to, my lord, to my instructions, my lord, there are, in other cases, lordship has put this condition. So, my lord, they, in rented house, my lord, they stay and they produce the documents, my lord, and thereby they are, my lord, facing the trial.
okay, shall not leave the jurisdiction of the court till completion of trial, and the petitioner shall not exercise threats to witnesses or try to influence them on breach of any of the bail conditions. The court is at liberty to immediately cancel the bail granted to the petitioner.
Difficult, my lord.
এখন ঘুরাইও করা। এটু ইয়ার আছে 19 or 48 সালে।
Like,
Lordship,
Yes.
I seek your indulgence to mention item number 57, your lordship.
You have a flight in the evening,
No, your lordship, tomorrow, your lordship,
sorry,
tomorrow.
tomorrow in the
I'm an
morning.
outside counsel, lordship.
What time do you want it to get upgraded now?
As your lordship may please.
Orders matter. Okay, you can place your submission. You want to press the I?
Yes, your lordship, for condonation, your lordship.
Register one I. Okay, then you'll issue notice.
Please, your lordship.
Delay of how many days?
Lordship, it has, the registry has noted a delay of 90 days, but
Oh.
your lordship, it is much less than that. It is around 20 days, because your lordship, it is to be counted from the day we receive the certified copies, your lordship.
20 days, even then you'll have to issue notice.
Please, your lordship.
Yes. Learned counsel, Mr.
Shaunak Dutt, SHAUNAK.
Please have. Fifty কিমান আছিলে এইটো?
Lordship, I would seek your indulgence for a short date, because your
Sure,
lordship,
sure.
the execution has also been filed in this matter.
Yes, yes. Where is the respondent's address? Short date?
Lordship, it is in Guwahati itself.
Guwahati, okay. Then is present You are on behalf of any other advocate?
No, your lordship, I'm the counsel.
Your name is not mentioned in the.
Is that the
Oh, okay, okay, yes, doctor. Learned counsel, Mr. S. Doctor is present. For the applicant stroke appellant, issue notice to the appellant to take steps to issue notice to the respondents through returnable within when do you want?
lordship, anytime as your lordship pleases, but shorter date, maybe next month.
Short date of the DDR. 28th of May
Please, your
or next month?
No,
28th
28th
of
of
May.
May.
28th of May.
Oblige your lordship.
Item 9.
My please, Lord. Well, this is regular second appeal, Lordship. The present appellant was the plaintiff in original suit, Lordship. The suit was filed seeking declaration of right title interest, recovery of possession, permanent injunction on the basis of Lordship inheritance right. Accordingly, Learned Trial Court, considering all matters, Lordship, suit was decreed in my favor. Considering all 9 issues in my favor. Then what happened, Lordship? If your Lordship kindly peruse page number 67, my plaint, Lordship,
Okay.
page 67.
Mm.
Here, suit was filed, Lordship, against 14-15 total defendants are there. Lordship, out of those defendants, only defendant number preferred the appeal. Only defendant number 4.
Okay.
So other 13 did not prefer appeal. Only defendant number 4. And interestingly, Lordship, that defendant number 4, after filing written statement, did not participate in the trial. He neither cross-examined my witness nor adduced any evidence from his side. Only filed written statement.
She's
That's
a
my
lady, you know.
Lordship.
Different number 4 is lady.
Yes,
Jyotsna
present respondent, Lordship. Present principal respondent. Neither cross-examined my witness nor filed his own evidence.
She did not participate in the original title suit.
Original title suit after filing written statement. Now kindly peruse Lordship appellate court judgment. Lordship will find at page number 87.
Do you have any caveat here? Do we?
No,
have any
no caveat,
Sure.
no interim application is there. Kindly peruse page number 109, issue number 8.
Okay. Issue number.
Paragraph 22, last 4 lines. First of all, Lordship, I have already submitted defendant side file on written statement. No counterclaim is there. Here, the Learned First Appellate Court, what did, Lordship? Last 4 line of issue number 8, paragraph 22. As such, in view of above discussion of issue number 5 and 6 and findings thereof, it appears that the said defendant number 4 has also right title interest over the suit land. Here, Lordship, the defendant number 4 did not file any counterclaim. And without any counterclaim, the Learned First Appellate Court, Lordship, decided right title interest over the suit land of the dead defendant number 4, that is present respondent, Lordship.
She filed written statement, no?
Only file written statement without any counterclaim. No counterclaim is there. And now, kindly peruse other aspect, Lordship. Trial court framed as many as, Lordship, 9 issues. Out of those 9 issues, trial court framed, Lordship, as many as 9 issues. Out of those 9 issues, the First Appellate Court decided only 3 issues. Issue number 5, issue number 6, and issue number 8. Trial court even did not touch, Lordship, issue number 1, 2, 3, 7, and 9. Only 3 issues were decided. And Lordship will find here at page number 95,
two point of determination was framed, but no decision and decision and discussion on that point of determination. Lordship will find page number 95, 2 point of determination, but no discussion or decision about these 2 point of determination. And another aspect is there, Lordship. If your Lordship kindly peruse
Page 90.
Lordship,
Last
page 95. Page 95. Lordship will find 2 point of determination. First point of determination was framed on the discussing issue number 5, 6, 7, 8, and 9. But issue number 7, 9 was not decided at all. Whereas that point of issue was point of determination was framed for deciding issue number 5, 6, 7, 8, and 9. But in the judgment, Lordship will find only decision of issue number 5, 6, and 8, not 7 and 9. And the second issue, Lordship, point of determination not at all decided. Then kindly peruse, Lordship, page number 66.
Yes.
Page number 66, Lordship. Lordship will find an order. My suit, original suit, was filed in the year, Lordship, 2006. And Lordship will find page number 66 order. In next page, Lordship, page number 67, a plant. This particular suit was filed, page number 67. This particular suit was filed by present respondent against his vendor in the year 2005, which was renumbered in the year 2007. And Lordship, that suit was dismissed. That is the order Lordship will find at page number 66. Plaintiff is absent from the court today without any steps. However, the defendant number is present by his counsel. It is dismissed for default of the
So
plaintiff.
this suit was renumbered.
That is another suit, Lordship.
New title suit 57 of 2007.
Yes, new
This is
number.
another suit.
Oh, another suit. Lordship, the learned trial, first appellate court decided right title interest in my suit, Lordship, without any counterclaim. Whereas that respondent, defendant number 4, filed another suit, this particular suit, before filing my suit against his vendor, and that was dismissed, Lordship. If earlier suit filed by that defendant number 4 was dismissed, how that defendant can get right title interest in my suit without any counterclaim, Lordship?
This defendant number 4, Jusna Bhattacharjee.
No, defendant number 4, Mujamil Haq. That is the present respondent, principal respondent, Lordship. Here in the appeal, present respondent, Mujamil Haq. Page number 2, Lordship will find in cost title. That Mujamil Haq was filed that suit. And the learned first appellate court decided right title interest of that Mujamil Haq in my suit. That is why, Lordship, I have proposed as many as 6 substantial questions of law. Lordship will find at page number 9. That 6 I made into 4, Lordship, in with sample language. If your Lordship kindly peruse. Almost 10. Supreme Court and High Court is also there. Same, Lordship. 1 and 2 in a, I made it number 1. Whether the first appellate court declaring right title interest in favor of respondent number 4 over the suit land based on cell deed number 5099/2002 is perverse and legally erroneous, given that the deed was neither exhibited nor proved as primary or secondary evidence under section 61 to 66 of Evidence Act, and the declaration was made without a counterclaim, despite the dismissal of his earlier suit, Lordship. So that is very much necessary, as because if your Lordship kindly peruse judgment, is Lordship will find a judgment passed in 2nd April 103, 1998. If your Lordship kindly peruse paragraph 8. Paragraph 8, Lordship. Almost similar.
This is not clear. The overlapping of words, but you read it,
Lordship.
Yes.
However, the court has noticed that the impugned judgment so and so, the learned trial court below declared the right title in interest of the defendant number 1 as a co-owner over the suit land on the basis of purchase the land to have been made by him, sell deed number so and so. Mere dismissal of plaintiff's claim in the suit would not automatically result in a declaration of defendant's claim to the suit. The defendant number 1 had not set up a counterclaim in which any declaration had been paid for.
Just a moment.
In
If it is mentioned in the written statement, then? If it is mentioned in the written statement?
No, no, Lordship, not at all.
Not mentioned.
Not mentioned, not mentioned. So in this particular suit also, defendant right title of defendant was declared without counterclaim. That's why this honorable this High Court set aside that order.
Okay.
And Lordship, in next judgment, paragraph 29 and 30 of Honorable Supreme Court reported in 2013, paragraph 28 and 29. So Lordship will find.
State Bank of India, National Housing Bank.
Yes, Lordship.
Which paragraph? Which paragraph?
Paragraph 29, Lordship, page 7.
Okay. Yes.
Paragraph 29. Under the Code of Civil Procedure, such a decree in favor of defendant is permissible in a case where the defendant either plead a set-off or make a counterclaim as contemplated under Order A. So there must be set-off or counterclaim. So without set-off or counterclaim, defendant is not at all entitled for any relief, Lordship, in a suit of plaintiff. And Lordship, next judgment, Lordship, in support of remaining part, that is Lordship will judgment of H. Siddiqui. Here Lordship will all principle is laid down with respect to adducing evidence of as primary or secondary. Here the defendant only filed written statement, neither produce death sale deed, his sale deed of 2002 as primary or secondary. So how that can be considered to declare right title interest without any counterclaim? And next judgment, Lordship, Somnath Hazari, paragraph 15.
This judgment, which paragraph? Siddiqui?
Siddiqui, Lordship, it's a paragraph in the principle laid down in various paragraph. Lordship will find from page paragraph 10 onwards. For considering any document as primary or secondary, the party must comply the principle laid down from section 61 to 65. Here in my case, Lordship, the defendant number 4 only filed written statement.
She did not file evidence.
Did not file evidence. The question of exhibiting any document without evidence cannot arise, Lordship.
Okay.
And next judgment, Lordship, in support of
This is para 10, no? Siddiqui's judgment is para 10.
Para 10 onwards. And next judgment, Lordship, in support of my substantial question of law, number 3.
Para 3.
No, in support of substantial question of law number 3. paragraph 15, Lordship. Here in this case, Lordship, out of 9 issues, only appellate court decided 3 issues.
Hmm.
There is no decision, discussion at all with respect to other 6 issues. And the point of determination was also not decided. Lordship knows very well, it is the duty of the learned first appellate court to comply the principle under order 41, rule 31. That was not complied.
Okay.
And Lordship, my another at the stage of trial, Lordship, the plaintiff partly withdrawn the suit against defendant number 2 and defendant number 7, partly withdrawn. Lordship knows very well the principle of order 23, rule 1. It is right of the plaintiff to withdraw part or whole claim. It is right, Lordship. Here, the first appellate court decided that since the appeal was, suit was withdrawn against the defendant number 2 and 7, so in that event, respondent, defendant number 4 will prejudice in the event of non-allowing his right title interest in my suit, Lordship.
Partly he has partly withdrawn the case against defendant number.
2 and 7.
Yes, what you were submitting?
My submission, Lordship, the first appellate court decided that since I have withdrawn the suit against 2 and 7, therefore the defendant number 4 will prejudice. If court don't pass any decree right title interest in favor of that defendant number 4, whereas that I am repeatedly submitting, Lordship, whereas that defendant neither file any counterclaim nor even adduce any evidence. That is why, Lordship, in this particular case, all 4 substantial question of law as proposed is as applicable. So that may be considered, and then notice may be issued, Lordship, to the opposite.
I'll have to ponder over it.
Lordship.
I'll have to ponder over it. I'll read the judgments and then I'll pass an order.
Lordship. My humble submission, Lordship, admittedly, all are applicable, Lordship.
It looks like.
Lordship, first appellate court is the court of both facts and law. So it is duty of the first appellate court to consider all the materials.
Yes.
If Lordship, first appellate court did not consider 6 issues out of 9 issues, so definitely my all other materials which attract other issues was not considered.
So if I feel that there are certain questions of law, then I can limit it to these 4 and 1 additional paragraph.
This 4 will enough, Lordship.
Okay.
This 4 will enough. That may be considered.
I'll read I'll have to go through this is a long case,
Lordship.
voluminous case. I'll have to go through everything.
Lordship. I have no.
I'll pass an order today itself.
Lordship. No stay order or other interim prayer, only appeal before your Lordship.
Okay.
Highly appreciated.
Item number 8.
2 more part.
May it please, your Lordship. My Lord, this is the second appeal against the judgment of London Lord Appellate Court, my Lord. Your Lordships, may draw your Lordship attention to page 3, the substantial question law I have formulated, my Lord. In a very small campus, I'll ask to place before the Lordship. And in the same subject matter, I have got a judgment of this honorable court, my Lord, exactly covered by my case, my Lord. So the matter will be very shortened before your Lordship's convenience. Page 3, your Lordship kindly see.
Page 3.
Yes.
Yes.
The substantial question of law, whether the courts will add in decreeing the suit, though the execution of the sale deed exhibit 1, being a certified copy was admitted, but the contents thereof being denied is required to be proved by calling the attesting witness and scribe and fulfilling the provision under section 63 and 67 of the Indian Evidence Act. That means, my Lord, as per section 63, 63 and 67 of the contents of the certified copy, execution may be admitted, but the contents has to be proved before the court, my lord. In this respect, I draw your lordship attention to the judgment I have given, my lord. Your lordship may be pleased to see paragraph 13. None of the your lordship has got it. None of the plaintiff's witnesses deposed a single word that described how the sale deed as per versions of the executant, the original defendant number 1, nor any of the witnesses deposed that the recitals of the sale deeds had been read over to the executant in their presence. In the present case, once the execution is admitted in the written statement, proof of the execution is not required afresh. But the recitals of the documents ought to have been brought on record either by examining the scribe or who wrote the same by your witness who was present at the time of executions of the document. But no such witness has been examined. This is our case, my lord. No scribe or attesting witness was examined by the court. Only they produced a document. According to me, it was a document for a rent agreement because the plaintiff was a tenant in my house. After completion of the tenant, the renewal was required. So I am a psychological patient, imbalance of my mind and brain does not work. It is somehow running the days, my lord. So I was called upon the court before the registrar. Yes, another deed of tenancy agreement will be done. But because taking the advantage of my ignorance and this thing, they formulated a sale deed, my lord. And subsequently, they are claiming that the land is, I am not entitled to, I am not bound to give you the payment of rent because I have already purchased the land from you. In this way, they are fraudulently dealing with me, my lords. Then subsequently, after 4 or 5 years, they filed a suit against me. On hand, they are not paying my rent. When I insisting on no, I am giving this thing, that thing. Later on, they raise a claim that no, I have purchased land from you because of my weakness and imbalance of mind, my lord. They took the advantage and claimed that I have purchased your land, this thing, that thing, and they filed a suit against me. Now in the suit, they are telling that this is a sale deed exhibit me, but that deed was never, I am admitting there was an execution. That execution was in respect of the tenancy agreement. And I was not that conversant, it was not shown to me, it was not read over to me or any of this. During the trial also, none of the scribe or attesting witness was examined. So exactly this judgment of this honorable court is covering my case. So I pray before your lordship, the two substantial question of law I has formulated may kindly be taken, my lord. My appeal may kindly be admitted.
So you see, these are two concurrent judgments.
Yes, concurrent, I admit, my lord. And this judgment you will also kindly see. And then the paragraph 15, 14 and 15 also may kindly read it. The counsel for the other side wanted to raise an objection, and it was then the learned judge of this honorable court, my lord, Mr. Dev, paragraph 15, you will also kindly see. 16, my lord. In the view of the matter, I am constrained to hold that the recitals of the purported sale deeds, Exhibit 1 to 5, having not been proved in accordance with the provisions of law, the learned First Appellate Court should have put up the reliance on the recitals of those purported sale deeds. My whole case is there was a fraudulent deed against me. I am a layman, my patient of balance. I have lack of wit, this thing, that in my lord.
Did you take this question of law, substantial question of law before the appellate court, first appellate court?
First appellate court, these are not considered, my lord. This question, first I have taken the ground. I have taken all these grounds to the first appellate court, my lord. Your lordship may be pleased to see page 40, my lord, 41, 41, 47, my lord.
40.
Hmm?
Yes.
Age,
Yeah.
age, my dear lordship, page 41. For that the learned trial court failed to consider the fact that exhibit 1 is a certified copy of the sale deed dated so and so, and the same has not been proved through proper evidence of the scribe and the attesting witness as per section 68 of the Indian Evidence Act, and the judgment and degree passed on the basis of the said document is highly erroneous. So, my lord, this I have taken the ground that the learned court failed to consider, and so I am bound to place this judgment of this honorable court, my lord. Paragraph 13 and 15, my lord. Only these two substantial questions of due, my lord. This will be considered after their appearance before the court.
Please sit down. Please sit down. Have you filed any application for stay?
Yes, my application is there.
Did you admit the execution of the document?
My lord.
Did the plaintiff admit the execution of the document? That it has been held by the appellate court
Yes, but
that the execution of the document has been admitted. So that document is not required to be proved under section 68 of the Evidence Act.
execution, my lord, execution I am admitting.
Ah.
Because according to me, they took me to the
Fraudulent
sub-register.
execution of
It was a rent tenancy
Yeah,
agreement,
fraudulent
according,
manner.
which was not read out to me. And none of the people told me that it is a sale deed. I believe that it is the agreement tenancy, my lord. So admittedly, she was in my tenant. Till date, she is occupying my rent, my house. As a tenant, my lord. Contents we are not admitting.
So that you are mentally ailing, you have taken this plea from the first.
In the both the courts, I took the plea because
Trial
of
court.
which I am bound to approach your losses, my lord. They could bitterly failed the two courts.
Just I'll read the plaint of the title suit.
Eh?
Have you annexed the plaint of the title suit?
Yes, my lord.
Only that part, if it is read, then I'll frame the question of law.
Plaint. Plaint starts from page 5, my lord. It is the most written statement. Hmm?
Yes, yes.
Should I read my,
Yes,
the
page,
plain to written statement?
plaint. Who is the, you are the.
I am the defendant, my lord.
Okay, written statement.
My written statement starts from page 12, my lord.
Okay.
Huh?
Entire written statement is not required to be
The
read.
ab-
Only that part that fraudulently it was procured.
My lord, I am taking from para 4, my lord. The amendment of para 4 is not correct. The amendments of the para 2 is what with, page 14. The my lord, I draw your lordship attention to page 14. Para D. D, my lord, your lordship, the para D. The plaintiff was very much aware of the fact and wanted cunningly to take advantage of this situation.
Okay.
This
Okay.
situation might
I'll frame
physical
the
imbalance.
question- I'll frame the questions of law. I'll admit and frame the questions of law, but stay I will not grant.
Stay, my lord, then at least.
We'll issue notice and then we'll consider.
Much
the-
obliged, man.
Learned, senior counsel,
MH Rajbur.
Mr. M.H. Raj Borbhia, who has filed, who is representing the appellant. Ajay Prasad Kanu,
Yes, madam.
who has preferred this appeal, this second appeal against the judgment and decree passed by the Civil Judge Senior Division Hailakandi in title appeal number 24 of 2023, filed order dated 21/12/2024, and the judgment and decree passed by the learned Musif number 2, Hailakandi in title suit number 194 of 2022 on 15/9/2023. It is submitted that although the decision, this appeal is against concurrent decision of two against concurrent decisions, concurrent decisions. So there are substantial questions of law to be considered. First off, I have considered the submissions at the bar. This appeal is admitted on framing the substantial questions of law as below. Number 1, page 312. Meanwhile, issue notice to the respondent. Only one respondent.
Yes.
That
Only one,
tenant,
madam.
that tenant, returnable within 4 weeks. Ito to likhi diba. Issue notice I to likhi diba.
And the records will be called for, madam.
Also called for the trial court records of TS
Oh,
number so and so and TA number so and so.
Much
List
obliged.
accordingly.
Much obliged.
Oh, A2 person, the learned counsel for the two agot admitted on, relied on the decision of two, paragraph 13. Or paragraph 13, 14, 15.
Yes. 13 and 15.
Huh?
13 and 15.
13 and 15. 13 not 15. Sorry.
Much obliged.
May it please your lordship.
Hmm.
Before I proceed, my lord, I trouble your lordship to one miscase so that your lordship will understand.
Hmm.
The miscase number is, my lord, 3481. Your lordship will look into the IA 3481. Your lordship has got it. In that 3481, your lordship will see the office record. where your lordship will find notice was sent, the office record your lordship will find. I am the defendant appellant hearing. Defendant in the suit, appellant hearing. It is the second appeal. Your lordship will just look into the office note of 3481. Your lord-
3481.
Yes, well, the office note.
Office note 1525.
My lord, your lordship has found it that
Ah.
the other side has received the copy. They have sent back the ID card, but they refuse to come before the High Court. But they are pursuing the execution case in the trial court. But
Okay.
they, after receiving the notice, they don't come before the court. That is why the delay condonation application was disposed of, condoning my delay.
Okay.
So now the second appeal. That is why I want to place it before your lordship, because notice was already sent to them. They have refused to come before this court. So my lord, I am the defendant appellant herein. My lord, I take your lordship to the second appeal to court court. Yeah. My lord, page 61, I will take your lordship to the plaint first. Page 61 is a one-page plaint. I am the defendant in the suit, appellant herein. In the appellate court, my lord, 3 issues which were in the suit, which were in favor of the plaintiff, was nullified, and it was in my favor, and it was in negative towards the plaintiff. Those issues were declared against the plaintiff, like recovery of possession, like that I am an illegal occupier, that I am having a lease. All these were nullified by the appellate court, saying it is against negative against the plaintiff. But my lord, I take your lordship to the plaint, page 61. It's a one-page plaint, my lord. My lord, your lordship has got it, page 61.
Yes. Yes.
My lord, at the first paragraph, it says about 4 biga 2 gata 16 lecher is the suit land. Your lordship, then my lord, the plaintiff says the father is Harakanto Gogoi in possession of the said plot of land since he got the patta of the cultivated land, also paid land revenue. At that time, total plot of land was such and such and such. Next page, my lord, your lordship will find para 3. That in the year 2000, out of total land of 4 biga such and such, lands was transferred in the name of plaintiff, which is the suit land, as late Harakanto Gogoi has already expired. So plaintiff's father expired. Next, my lord, late Harakanto Gogoi gave the said plot of cultivable land measuring 4 biga such and such to late Chittaranjan Das for cultivation. Chittaranjan Das is the maternal uncle of the defendant appellant herein. Chittaranjan Das for cultivation on lease system for a term of 1 year, and he had been paying the lease amount each year to late Harakanto Gogoi. Next, late Harakanto Gogoi expired 20 years ago, and after the expiry, late Chittaranjan Das had been paying the lease amount to the plaintiff every year regularly. Late Chittaranjan Das expired in the year 2005, and he is the maternal uncle of the present defendant, Somiran Karmakar. So your lordship has got it. Next, that after the expiry of Chittaranjan Das in the year 2005, the defendant, Sri Somiran Karmakar, illegally occupied the said plot of cultivable land. Here the word is illegally occupying the plot of land. That means the defendant is in possession of the land, of the cultivable land, and he refused to pay the lease amount, claiming that he is the owner of the said plot of cultivable land. Next, para 8. The plaintiff filed a case before the ARO Pulumi Circle, that is Assistant Revenue Officer, against the present defendant Somiran Karmakar. ARO has pleased to pass an order dated 16/3/2007, stating that the patta issued in the name of Somiran Karmakar, that annual patta was issued in the name of defendant Somiran Karmakar, and was found some anomalies in the office record. He directed to issue fresh patta in 2 kata only to the defendant. So there was already a direction to pass a patta in the favor of the defendant. Next, my lord, that in spite of the said order of the ARO, the Pulumi Circle, the defendant have been occupying the said plot of land illegally. That I am occupying the plot of land illegally, and he is construction house over the said plot of land. The defendant has no right, title, and possession and construction over that. The cause of action is of 2005. Your lordship will find the cause of action, they have said 2005, and the suit was filed in the year 2013. So after, my lord, around 8 years. So it was after a long period. The suit value is such and such. So their plea is, my lord, there is having a lease to us, and the lease, after that we are occupying the plot of land. we are cultivating over there and we are not paying the lease amount to the plaintiff. And our case was that we have been allowed a annual patta to us by the AR, Assistant Revenue Officer, where on that annual patta there was an anomaly, and that anomaly was thereafter to be directed to be corrected and the fresh annual patta to be passed to the defendant. Then, my lord, in the suit, the plaintiff, that the suit that was filed by the plaintiff, your lordship will find, it starts at page 8. Your lordship has got it, page 8.
This is the plaintiff, no?
My lord,
Sandika Gogoi is the plaintiff.
plaintiff, who has also received the notice,
That was page 61.
page 61.
Then
That was his,
another?
that was the plaint by the plaintiff. I am the defendant in the suit.
Oh, you have also filed the suit.
I am the defendant in the suit.
Understood, yes.
So I am not
Sir,
the plaintiff.
You are asking me to check page 8 for another title suit?
Title suit was because this is a second appeal.
Ah.
So I have to look into the suit, then the first appeal, then I have to place it before lordship, the second appeal.
Then page 8 is what?
For the suit filed by the respondent plaintiff. Suit filed by the respondent hearing the plaintiff.
Page
I am
8?
the page 8 is the suit.
And page 61 is?
Page 61 was the plaint of the plaintiff.
Okay, okay.
Plaint of the plaintiff.
Ah.
Because I want to place the facts. What was the case of the plaintiff before the suit, before the trial court? I have read the plaint because to assist your lordship to make it understand what is the case of the plaintiff before
So
the
this is the judgment, page 8?
judgment.
No, you kept on saying suit. That's why I'm asking. Page 8 suit.
My lord, page suit
Page 8 is the judgment.
judgment of the suit, not the appellate court. It was judgment of the suit. My lord, the issues that are framed, that is at page 13.
Okay.
My lord, the main issues are, my lord, your lordship will find issue number 3, the plaintiff, whether the plaintiff have right title interest over the suit land mentioned in the schedule of the plaint. Next, whether the father of the plaintiff delivered possession of the suit land to the maternal uncle of the defendant, Dikesh Chittaranjan Das on lease. Next, whether the defendant since the death of Chittaranjan Das has been occupying the land illegally without paying lease to the plaintiff. Whether the plaintiff are entitled to recovery of the possession of the suit land. Whether the plaintiff are entitled to a degree as prayed for. Whether the plaintiff is other relief. So the main issues are, my lord, from 3 to 6. 3 to 6 are the main issues. My lord, now while deciding issue number 3, that is the right title interest, it starts at page 16.
Yes.
My lord, I take your lordship, I will skip over. I take your lordship directly to page, my lord, page 19.
Page 19, okay.
19, last paragraph. Last but 1, 2, 3, 6, 7 line, my lord.
Okay.
It starts with, as I already mentioned, page 19. Your lordship has got it?
Yes.
Page 19, last but 7th line. It starts with word as. As I have already mentioned above. Your lordship has got it?
Yes.
Mentioned above, the certified copies of the original document issued by the appropriate authority can be presumed to be genuine under section 79 of the Evidence Act. So the plaintiff failed to produce all the original documents. He only produced the certified copy. And the trial court, on the presumption of section 79 of the certified copies of the original documents, has presumed those documents as genuine. Has presumed those documents as genuine. Because, my lord, under the Indian Evidence Act, section 79, before, if I go to section 79, the bar is at section 4. So, section 4, my lord. The bar is at section 4. My lord, may I, if you're
Evidence account. Not a civil matter. Yes, you can read.
My lord,
Mm.
section 79 says, the court shall presume to be a genuine every document purporting to be a certificate, certified copy, or other document which by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer of the central government or of a state government or by any officer in the state of Jammu and Kashmir, which is duly authorized thereto by the central government, provided, there is a proviso, provided that document is substantially in the form and purports to be executed in the manner directed by law in that behalf. Until and unless, my lord, this proviso means, my lord, which is included in the main section. Proviso cannot exclude the part. It is always inclusive of the main section, provided that such document is substantially in the form and purports to be executed in the manner directed by the law in that behalf. So the way it has to be executed, until if a certified copy is there, I have to call for the original record to prove it that this is, until unless it is proved the way it is to be executed, it cannot be genuine, it cannot be presumed to be genuine by the court. And the bar is at section 4, my lord. Section 4 says, it starts with, my lord, 59 Supreme Court, the basic is of 59 Supreme Court, which is the court, section 4 say, what is may presume, shall presume, and conclusive proof.
Mm.
Section 4. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. May call for proof of it. Shall presume, whenever it is directed by this act, the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. And next, conclusive proof, when one fact is declared by this act to be conclusive proof of another, the court shall on the proof of one fact regard the other as proof and shall not allow, this will not come in my case, will not allow evidence. So it is, the court may presume those facts to be genuine when it is executed and proved in the way the law declares it to be proved. So it was, nothing was done here in this case, certified copy was done and the court held to be genuine. Now, my lord, I take your lordship to the appellate judgment. My lord, before I go to the appellate judgment, I will take your lordship to the other issues in the suit's judgment, page 24. Page 24. Page 24, the other issues. Issue number 4 and 5. The operative portion is at page 26. Operative portion, issue number 4 and 5 was whether I have, my lord, issue number 4 was whether the father of the plaintiff delivered possession of the suit land to the maternal uncle, and 5 was whether the defendant, since the date of occupying the land illegally without paying lease to the plaintiff. That was 4 and 5. It starts at page 24 and the conclusive is at page 26. Your lordship has got it, page 26. In the light of the above discussion, I come to the conclusion that the suit land was given on lease by the plaintiff father, late Horakanta Gogoi, to the maternal uncle of late Chittaranjan Das. Since the defendant, after the death of Chittaranjan Das, took over the possession of the suit land and refused to pay the lease amount, he is occupying the same illegally without, accordingly, the issue 4 and 5 are decided in positive. So the court held that I am occupying the land illegally. And regarding 6 and 7, next clause number 21, issue number 6, since the issue number 1, 2, 3, 4 are decided in favor of the plaintiff and the defendant is occupying the suit land illegally, the plaintiff is entitled to recovery of possession of the suit land. Accordingly, 6, 7, 8 are decided in favor of the plaintiff. That was the suit. I went for a first appeal. So, my lord, after in the appeal, your lordship will find that issue number 3, where it was decided, if the appellate judgment starts at page page 33. It starts at page 33 and the, my lord, issue number 3 is page 46.
Okay.
Page 46, number 23. The most vital issue in this case is issue number 3. Your lordship has got it. Then while deciding issue number 3, my lord, at serial number 29, page 49.
Yes.
Page 49, last line, your lordship will find. serial number 29,
Yes.
last line.
Yes.
Plaintiff side has submitted the documents in original and find nothing to disbelieve the documents. The trial court has said these are all certified copies and presumption of section 79 has come. And where from these original documents come over before the appellate court?
Para 29.
Para 29, my lord, page 49, para 29, last line.
Plaintiff side has submitted.
Where from this has come? Your lordship, I have seen, place it before the, your lordship, that in the trial court, these were all certified copy and it was, and now where from these original documents come? And on this perversity, the court held that the right title has been able to prove. So, my lord, and the issue number 3 was decided in their favor at page 54. Page 54, CL number 36.
Okay. All right.
That the right title has been declared in favor of the plaintiff. As regard 4, 5, 6, 7, 8, my lord. Next, it has started with issue number 4 and 5, serial number 37. My lord, at page 55, last part, my lord, 1, 2, 3, 4, 5, 6, 7 line, my lord. In my opinion, my lord, page 55.
Yes.
In my opinion, your lordship has got it.
Yes, yes.
In my opinion, plaintiff side has failed to prove the suit land was given on lease to the maternal uncle of the defendant. Since the factum of lease is not established in this case, the claim of the plaintiff side that the defendant after death of Chittaranjan Das took over the possession of the suit land and refused to pay the lease amount and also occupying the suit land illegally is not tenable. The plaintiff side did not, next, my lord, did not mention anywhere the date of the or the year in which the suit land was given on lease to late Chittaranjan Das. Next, para 38. From the discussion made above, I am of the considered view that the plaintiff side has failed to prove the suit land was given on lease to late Harakanta Gogoi to late Chittaranjan Das. Moreover, it is not proved that after the death of late Chittaranjan Das, the defendant started occupying the suit land illegally. I do not agree with the observation made by the learned trial court. Hence, the issue 4 and 5 are hereby decided against the plaintiff. So this has been held against the plaintiff. And next para, my lord, page 39, para 39. Learned trial court decided issue number 6, 7, 8. Your lordship has got it.
Yes.
Together. I am also taking up all these 3 issues together for the sake of convenience. While deciding the issues, learned trial court held that the plaintiff are entitled to recovery of possession of the suit land. However, after going through the plaint, it is found that plaintiff did not make any prayer for recovery of possession. Rather, the plaintiff prayed for confirmation of possession. So there was no question of recovery of possession. So this was also decided against the plaintiff. This issue is also decided against the plaintiff. So there was no prayer for my lord, recovery of possession. So 4, 5, 6, 7, 8 all are decided against the plaintiff. Only point that was decided in favor of the plaintiff is right title interest, that too on perversity. And now what they are doing, my lord, after receiving notice,
Yes.
they don't come before the High Court and they are pursuing the execution case there. And my lord, my substantial question of law are there in a page, my lord.
We'll take up after
Lunch.
After lunch.
My lord,
Others are waiting maybe
my lord,
for a break.
my lord. It will that it will- Though at the cost of repetition, I will place the facts again, my lord, your lordship will permit me. My lord, here the appellant is the defendant in the suit. The plaintiff filed a suit. The prayer was there that they have given a lease of the suit land to me, and my maternal uncle was there. Thereafter, I have come over being, and I am not paying the lease amount and illegally occupying the suit land. And there was a prayer for confirmation of possession. My lord, issue number 3 was for right title interest, and 4, 5 was whether there was a lease given to me, and 5, 6 were for recovery of possession. Suit was there. Trial court decided on the basis of presumption, because only certified copies were given, no original documents were produced, and it was not proved according to the procedure that is to be proved. And on the presumption, trial court held that.
So this, what are the documents which were given in copies?
My lord, the documents, it has been laid down, my lord. Your lordship will look into it. That is my lord, page 16.
Hmm.
Page 16, paragraph number 11,
Hmm.
issue number 3.
Hmm.
Your lordship has got it.
No.
Page 16, paragraph number 3, middle portion. The plaintiff have exhibited several documents in support of their case. Exhibit 1, annual Khiraj Patta of land measuring, dag number. Exhibit 2, certified copy of order of ASO, ARO, ASO, full officer.
One is Khiraj Patta,
Khiraj Patta,
AP.
AB, my lord, and then
Annual Khiraj Patta.
annual Khiraj
AP.
Patta. Exhibit 2 is the certified copy of order dated such and such. Exhibit 2 is a periodic Khiraj Patta. Exhibit 4 is Rajarat Khiraj annual Patta of
This
the
is
suit.
PP.
BP, my lord. So all these are all the certified copies. These are all certified copies which has been laid down, your lordship, in paragraph.
Any reason why he couldn't produce the original?
That is the plaintiff's fault. Plaintiff's burden is to prove his case. I am not the plaintiff. Why he has not been able to, that is his case. And ultimately, the court held at page 19 that under section 79 of the Indian Evidence Act, presumption has been taken, the certified copies, though it was not proved according to the way it has to be proved. That presumption was taken. And ultimately, appellate court held that those were in original. But from it is absolute perversity. When trial court held, it is a presumption of the certified copy. And my lord, as regards lease, the appellate court held.
So he has an annual Patta and Khiraj Patta also.
My lord, all this, and me also having an annual Patta. Me is also having an annual Patta which I have exhibited. And ultimately, my lord, the court held that there is no recovery of possession, no lease, and I am not occupying illegally. That is in the appellate court. Your lordship has, I think I have placed that already before your lordship.
Okay.
Now, my lord, my substantial questions of law are at page 7. First of all, I have placed before your lordship the plaint. They have stated the cause of action is of 2005.
Hmm.
And they have filed the suit in 2013. So, my lord, clause A, whether the suit of the plaintiff respondent for declaration of right title, interest and confirmation filed in the year 2013 is barred by section 113 of Limitation Act as the cause of action arose in the year 2005 as pleaded in the plaint. So this is first my substantial question of law. My lord, because
That prayer was for confirmation of
for
title.
the confirmation of position,
Not of
for recovery of position, not for recovery. And ultimately they have filed an execution case for recovery of position. And they are not, though that they have received the notice from this court, they don't appear before this court. Because they think that the more the delay is there, they will execute me and throw me out and ultimately nothing will remain. And my lord, then B I will not take because B was in my favor. B, the court held that there is no lease, the appellate court. I have placed already before your lordship. C, my lord, your lordship will find whether the impugned judgment and decree declaring the right title of the plaintiff over the suit land, considering the document exhibit 1 to 16 as original and presumed to be genuine under section 79 of the Evidence Act, is perverse as documents are certified copies which are merely exhibited without proving the contents of those documents as per Indian Evidence Act. So, my lord, appellate court held original and the trial court held it is a certified copy. So there is absolute perversity. C. And the D, my lord, whether the impugned judgment and decree declaring the confirmation of possession of the said land in favor of the plaintiff respondent is not first perverse as the plaintiff respondent failed to prove his possession of the suit land. The plaint itself says that I am in possession. So wherefrom they can ask for a confirmation of possession? So there cannot be, they have not proved the confirmation of possession. Their plaint itself says that I am illegally occupying the plot of land. So there cannot be a question of confirmation of possession. And the appellate court held that there is a confirmation of possession. When there I am illegally occupying the plot of land. And their plaint itself says at page 61, your lordship will find. Page 61, I have already placed before your lordship. Page 61. In page 62, the relevant portion, my lord. Para 9, that in spite of the said order of the heir of Fulumi Circle, the defendants have been occupying the said plot of land illegally and is constructing the house over the said plot of land. Your lordship has got it? So, my lord, that is confirmation of possession is also perverse. So this is on these three substantial of portion of law, my lord, I pray for a admission of this second appeal on clause number A, clause number C, and clause number D.
Okay, are you paying for stay?
Because,
paying
my
for
lord,
stay?
because they on receipt of notice, they are not coming and they are pursuing that exhibition case. If they, I am thrown out, my lord, nothing remains. So, my lord, there is a miscase I have filed, IA 1410. And I have placed before your lordship, they have received notice, they doesn't appear before this court. 1410. I have prayed for the stay of the judgment, man.
The proceeding with the execution proceedings.
My lord, no judgment of the
Filed an
appellate.
Execution procedure.
They have filed an execution case. They have filed an execution case. My lord, I have prayed for a judgment, impugned judgment and decree dated such and such per civil judge at page 5 of the IA, my lord. Page 5 of the IA. 1410.
Okay, I'll, about stay and everything, I'll pass an order later.
My lord.
Today or maybe within this week.
My lord. Because, my lord,
I know.
they will
They
throw me out
will,
and I'll be.
they'll throw
And
you
my
out.
lord, my substantial question of law is A, C, and D. A, C, and D, page 7.
Yes, I have marked. You do not
ACS.
want B,
B is in my favor, madam.
C and D.
AC.
Page 3, no?
Page 7, madam.
Page 7.
Page 7.
Maybe I'll pass an order today itself. A, C, and D.
My lord.
Okay.
Obligement.
এই দুটো আগে দিব লাগে। পাহৰি যাওঁ। Yes.
My lord, I am seeking bail on 3 grounds.
Hmm.
One, my lord, inordinate delay.
Hmm.
Because your lordship earlier order page 40. There is the direction of your lordship to expedite the trial. Page 44 is the relevant portion. However, my lord, till date, only one PW was examined. I was arrested,
Till now, till date, how many PWs have been examined?
only one
Out of?
9, my lord.
Okay. You were arrested on?
Arrested on, my lord, 7/6/2023. It is 1 year, 11 months, 7 days.
Okay.
And my lord, my second ground, my lord, on the same footing, my lord, co-accused have been granted bail, who was arrested on same,
Technically.
Zabel Hussain, my lord. Who was arrested on same footing, was granted bail by your lordship, page 45.
Okay.
And third ground, my lord, page 37. This, the grounds of arrest were not communicated. Page 37, 38, and 39. This is in violation of Bihan's command.
Okay. Where is the other side? PP, where is PP? And NCB,
Not at
nobody,
Assam.
nobody is around. Assam,
Assam.
PP. PP is not here. Nowadays, PPs do not take interest because you always come up with grounds of arrest. You have seen the LCR?
Lordship, charge framed on 19/12/23. Out of 20 PW, no?
19, 12, 23.
23. in 19/12/23.
Only one witness
Only
examined.
one witness examined on 18/3/25.
What is the contraband
Contraband is
amount?
heroin. 300 gram of heroin shipped.
Anything else? Grounds of arrest?
Grounds of the match that matter, that's not it.
Nothing.
Grounds of arrest
My
memo,
lord, three grounds is there for.
arrest memo and
Give me the judgment.
Yes, I'll show my lord. It is, I'll place my lord after some time, all judgment I will.
50 shares.
Which judgment you want to place?
Number one, my lord, Bihans Kumar, Prabir Purkasto and Sharifuddin and.
No, no,
Ravindra Kumar Chau-
not so many. Two will be enough. I'm granting bail. Two will be enough. Heard learned counsel, Mr. H.R. Sodri for the petitioner.
Only the non-compliance of ground of arrest.
Yes. Abdul Hasim, who has filed his application under section 483 of with 2023 with prayer for bail as is behind bars since 7/6/2023 in connection with special NDPS case number 59 of 2023 arising out of so-and-so PS case under so-and-so sections. It is submitted that the petitioner's right to personal liberty has been curtailed as the petitioner was arrested on 7/6/2023 and only one out of
20 people.
9 witnesses have been
Nine.
examined so
Only
far.
One witness is examined out of 20 PW.
Oh, only one out of 20
20.
witnesses have been examined so far. To stop, it is submitted that the culmination appears to, culmination of yes, culmination of trial appears to be remote as there are 20 witnesses to be examined in connection with this case. To stop, the trial has been procrastinated by the court as well as by the state. Moreover, the grounds of arrest has not been communicated to the petitioner in the manner to be understood by the petitioner. Annexure, which annexure?
My lord, grounds for page, annexure 5, 6 and 7.
Annexure 5, 6, and 7 are the notices under section.
Notice, inspection memo and arrest memo. Notice under section 50 CRPC.
5, 6, and 7, no?
Yes, ma'am. Page 37, 38 and 39.
Are the notices under section 50, annexure 5, 6, and 7 are the notices under section 50 CRPC, inspection memo and the arrest memo, which clearly reveals that the grounds of arrest were not communicated to the petitioner in a manner to be understood by the petitioner. Most of the petitioner has also prayed for bail on the ground of parity as co-accused, who is on the same footing, has already been enlarged on bail in connection with Abdul Hasim.
No, my lord, in the page 45 is the co-accused bail order.
Jabel Hussain, alias Jabel Hussain versus State of Assam, in bail application number 3015 of 2024, where by order dated 8/4/2025, this court has granted bail to the co-accused of the petitioner. The learned addition PP has raised serious objection, stating that they are incriminating materials and a prima facie case against the petitioner. The petitioner was apprehended while transporting 300 grams of heroin. To stop, the petitioner is booked under a heinous offense and he is not entitled to bail. I've considered the submissions of at the bar with circumspection. It is true that the grounds of arrest has not been communicated to the petitioner in a manner to be understood by the petitioner. The petitioner has also relied on the decision of the Honorable Supreme Court in Prabir Purkasto versus, you give it a judgment. And in reported on and in the decision of the Honorable Supreme Court in Vihan Kumar versus
State of Haryana and another.
State of Haryana and others.
Reported in 2005, 0 SC 283.
You mark the paragraph.
Yes. Page 46, madam. Page 46.
Page 46.
46, madam.
Okay.
In middle, madam.
ইয়াত আছে পেজ 46 আৰু পেজ 47 ইয়াতে আছে তাতে তুমি তাৰ পৰা উঠাই পেলাই কৰি দিলে হৈছে। In the light of the decision of the Honorable Supreme Court in Prabir Castor's case and in the case of Lian Kumar, it appears that bail may be granted to the petitioner. The petitioner is therefore enlarged on bail of rupees 1 lakh with 2 local sureties of like amount with the satisfaction of the learned trial court under the condition that the petitioner shall 46 or 47 day. Lian Kumar Prabir Castor. Under the condition that the petitioner shall refrain from such activities with which he is alleged, but to the petitioner shall not leave the jurisdiction of the court without prior permission with completion of trial, and the petitioner shall not exercise threats to witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
May I please, your Lordship?
Yes,
Lordship,
yes.
matter may be withdrawn. I have the instruction read.
Sorry,
Matter may be withdrawn.
item number 2.
Hmm.
Learned counsel, Mr.
A.S. Chaudhary.
A.H. Chaudhary is present. A.S. Chaudhary is present for the petitioner and is paid for withdrawal of the petition. Third learned addition PP Mr. D.P. Goswami. Petition is dismissed on withdrawal.
Item number 11 for orders.
In this case, actually, we have taken step on, there is a IA file for substitution. 2924. In this IA, we have taken step, but till now they have not responded yet. Nothing is.
For aspirant one,
And
and aspirant one has already written legal assistance substituted. Aspirant one, legal has been substituted.
yes, my lord, your lordship, that is Mohat Chandra Das was the respondent number 1, but he expired. Because of that, we have filed this petition of substitution. But in that substitution petition, when we have taken step on the other respondent number 2 and 3, we couldn't, they are not, the service was not completed. But respondent number 1 has, for whom we have actually filed a petition, they have appeared in the case and they have accordingly, they are here. Maybe amended post title may be submitted in this case.
This matter has come up after 5 months.
Yes, my lord.
So there's nothing relating to other respondents.
No, nothing.
Okay. You'll issue a fresh notice.
As your court says, but then I do not think, because in the lower court also, they are not appearing in this case. And my lord, there is a stay order actually in this suit for executions, and they are proceeding with the execution, and for that we got a stay order from this honorable court, and that order should be continued. Two zero double nine.
This is IA.
Yes, that is 2099 is an IA and 2924 is also an IA. 2924 is for substitution. And 2099 is for stay.
You are pressing the IA?
Yes, my lord, this we have.
There,
taken
IA, there is nothing, we'll just continue with the stay order.
Yes, 2920.
And then what about the other IA?
That is, my lord, that is the substitution case. But then in the substitution too, you have already, they are already appearing, the for whom we have.
Respondent one.
Respondent number one, who, no, we wanted substitution for respondent number one only. And respondent number one has already substituted and their legal hair has been appearing in the case. My lord, in this case, actually, we need to amend the cause title.
In the main case?
Yes. Cause title of the appeal should be amended with the substituted. That's why they always.
I'll go one by one. Learned counsel, Mrs. S. Goswami.
Yes.
Is present for the applicant, IA to the 2099. And learned counsel, Mr.
S.A. Bhakhtiar.
S.A. Bhakhtiar is present for the opposite party. The stay order shall remain in force till the next date of listing, full stop. Then the other one?
And the other one is 2924.
Substitution.
This was substitution.
Okay. Was filed within the period of limitation?
Yes, within the period.
Learned counsel, Miss R. Goswami is present for the applicant.
Yes,
IA
please, ma'am.
2924, huh? Learned counsel, Mr. Bhakhtiar. What? S.A. Bhakhtiar is present for the respondent number one. Full stop. This is an application under order 22 rule. What will be the rule?
4.
Rule 4.
Rule 4 of the CPC for substitution of the legal heirs of the respondent number one, late Mohad Chandra Das.
Yes.
Mohad Chandra Das. The legal heirs are named in the legal heirs of late Mohad Chandra Das are, have you named him?
Yes, ma'am. In the prayer person. Mrs. Aruna Kakoti Das, wife.
Mrs. Orna Kakoti Das and
Parthapratim Das.
Mr. Parthapratim Das being wife and son.
Yes.
Of the deceased, full stop. After considering the submissions at the bar, petition is allowed. The prayer for substitution of legal heirs of late Mohad Chandra Das is allowed. But applicant to an amended cause title may be filed in the
that is
in
RFA.
the RFA number
59 of 2020.
2020, including the legal heirs of the deceased. Then in terms of the above observation, this IA stands disposed of. Eta disposed of, eta consulting.
2924. Obliged.
And what about the RFA? We'll list it when? When do you want to get it listed? RFA list this matter on after 3 weeks. After 3 weeks. RFA list this matter after 3 weeks.
Your Honor, the Lordship, the LCR may be called.
Meanwhile, call for the, I'll just check whether LCR has been called early. Early. No, LCR has not been called. Only steps have been taken, no? Meanwhile, call for the LCR, hey, to likhiba RFA, call for the trial court records. Yes.
Not surprised.
Item number 12.
Yes, please.
Area application 2249 has been filed for setting aside the order dated 15/11/21, where the yes, Honorable Court has dismissed the CRP 272/13 for non-prosecution. Therefore, where the notice was issued, respondent has appeared. In the meantime, the petitioner was expired. So another IA has for filing the substitute the legal year. The IA civil 2162/24. Yes, sir.
One is IA number
22449
of 2021.
21, who is for setting aside the order dated 15/11/21, where the dismissing the civil division petition 272/13.
CRP. Okay. Then, okay. And the other IA?
Other IA for during the pendency of this petition, the petitioner was expired. That's why his legal here.
Substitution of legal is.
Substitute application has.
IA number?
IA number 2162/24.
Another IA? No more.
No, it's,
May I please, Your Lordship? I'm for respondent number 3, Your Lordship. And we were.
Who has expired?
Applicant, petitioner applicant, Hirendra Kumar Bhattacharya. Petitioner.
Today we have only 2249 before us in the cause list. We do not have the other IAs before us. We'll take up only one matter which is before us.
249.
Yes, 2249.
But they have appeared, they're supposed to file their objection, but till they have not filed on.
Dismissed for non-personal. Appear for the petitioner when the matter was taken on. দুটো ডেট তাৰপিছত তিনটা ডেটৰ ৰাখা নাই তাৰপিছত ডিসমিস কৰি দিলে only one respondent has appeared. What about the other one? Written objection to be filed by counsel. Have you filed a written objection?
Lordship, what has happened is, we were informed by respondent number 3 that the High Court have sent an issue a notice, and they have sent us back the notice as well as the petition. But we have no instruction, Lordship, that if the decree has been executed in the meantime, or if he has any objection we filed for this petition.
No, can you obtain instructions as you are appearing?
If Lordship can grant 4 weeks time, Lordship.
Yes. আর মিস আর বেগম learned counsel for the এটুক লিখিবা হা applicant and Mr.
MM Kashyap.
MM Kashyap,
For respondent number 3.
learned counsel for the respondent number 3 and has submitted to obtain instructions relating to filing of objection. Okay,
Yes, Your Lordship.
this matter after 2 weeks, 3 weeks,
4 weeks.
4 weeks. Okay with you? 4 weeks?
2 weeks.
2 weeks, okay. 2 weeks.
Highly obliged, Your Lordship.
Well, in this matter, I was, this matter was assigned to me as a legal aid counsel. I am no longer a legal aid counsel now, but I do check out whether to return the brief to the authorities. So let me give it some time. I will have it check with the.
And so far as the calling out report is concerned, that is not yet to come, we have
Sorry?
received.
Yes, yes.
Report.
There was a
with
report called
respect-
by this honorable court, Ballot. Because
From
I
the learned
alleged
counsel number one current.
violation of status quo order.
Okay.
So that report was called for.
That has not been arrived.
Okay.
A reminder maybe.
Our learned counsel, Mr.
R. Chakraborty.
R. Chakraborty, who has submitted that he was appointed as a legal aid
legal
counsel,
counsel, yes.
but now you are not the legal.
I'm
aid
not in the list, madam. I'm not in
But-
the panel.
But now he is not enlisted as a legal aid counsel. Had Mr. U. Dutta, who has submitted that report regarding violation of injunction order, has been called for
From the office
from the office of the Munsif one, Karimganj, comma, within bracket Sri Bhumi. Await for the report, or shall I issue a reminder?
Reminder.
Issue a reminder to forward the report. List the matter after 2-3 weeks. Which week? 2-3.
After she,
After 3 weeks.
because it has to come from Korean.
Hmm.
Item 14.
Is it as per the last order, steps were taken and respondent number 1 and 3 has appeared. In 2, I'm not sure, I couldn't go through the record.
Respondent number 1 and 3 has appeared. You have 3 respondents?
Lordship.
Check. I think they have received the notice, but they are not appearing.
Lordship. Wait a minute.
Hello, check with দিয়াচোন হেৰি respond number 2 notice পাইছে order আছে Learned Counsel Miss
M. Sahu.
M.
Sahu.
Sahu is present for the appellant. Item number 14, no?
Yes, Lordship.
Appellant. Learned Counsel Mr.
G. Kaushik for R. Sensua.
G. Kaushik is present on behalf of Learned Counsel Mr. R. Sensua, representing respondent number 1 and 3. Notices, office note dated 9/5/25 indicates that notices has been received by Rita Deka.
Rita Das.
Rita Das.
Rita Das.
Rita Das. Which indicates that notices have been served to respondent number 2. We have called for the LCR, no, Agote?
Yes, no, LCR has been called.
So we will place it for admission, already admitted. Already
Not
admitted.
admitted, Your Lordship. Not yet admitted. It yet to be admitted.
No, admit first. It has been admitted.
Admission here.
Admission hearing. then.
It has been admitted. So we'll place it for hearing,
Yes.
or we'll wait for service of notice.
Your Honor, actually, the second party, the Rita Das, is their sister and daughter. So if they can contact, so they
We
may,
have not received instructions to appear for her yet.
if they're all family members.
So we'll list it for hearing then. List this matter for hearing.
Okay.
LCR has been received. Huh? So what he said. LCR is received, list this matter for hearing. However, check for you, cross check for you. এইটো কিমান হেৰি নতুন কেছ আছে this matter for, do you want a time frame for listing this matter for hearing? নাইকিয়া কৰি নালাগে list this matter for hearing সেইটোলৈ যাব
Item 15.
Meet resolution. Lordship, there is an application for substituting the legal heirs, and there is a delay of 1,829 days. And Your Lordship, we have substituted them, but no one has appeared.
substituted already.
Yes. The sole respondent. Your Lordship may look at the order dated 12/8/2024.
In which one? There are 2 IS and one
In
main case.
IA 297.
IA 297.
297, yes.
Order dated
12/8/2024.
No, this is relating to no service of notice only.
Your lordship, it states that the service is deemed to be served.
Yes,
So that steps is we have taken.
yes, yes.
Uh,
But they have
however,
not appeared.
no one is appearing for them. On the death of the respondent, their legal heirs 1 to 5 has been substituted.
Where?
Your
Can
lordship,
find.
the post title will show on the death of Sri Tikendra Chandra Singha. 1 Nilima Singha, 2 Anima Singha, 3 Nameshwar Singha, 4 Ani Singha, and 5 Kati Singha. They are the legal heirs of the sole respondent.
In the main case?
No, in this 297.
In 297?
297. Because this has to be allowed first.
Post title?
Yes, in the cost title.
Number?
Page number 4.
Oh,
The
yes,
opposite
yes,
parties,
yes.
yes. They are the newly
Nilima Singh, no?
Nilima, Anima, Nameshwar, Ani, and Kati.
So now you'll issue notice to the substituted legal heirs.
Lordship, notice I think was already issued. That notice upon respondent one deemed because it has been already deemed to be served. So there is another order 17 to 23 that reflects that notices were issued. One office note dated 1/3/23 that also shows that notice has been issued
To the to the legal heirs,
to the legal
representatives
heirs.
of deceased respondent number 1, late Tikendra Chandra Singh.
Yes.
Okay. And where is the office note?
1/3/23 that shows that notices has been issued. So just
Respondent number 11, 12, 13, 14,
and
15.
yes.
Okay.
Thereafter 28/3/23 that shows that the service that shows the service report.
So 214 and 15 notice could not be served because notice office note dated 7/8/2024. Huh? Registered post with AD unserved notice has returned for respondent number 11 with comment addressee left without instructions.
However, thereafter 7/8/24 that shows that service is complete. Lozima order.
14 and 15 with comment no such person in the
Such person in the
address. So only 1, 2, and 13 maybe.
1
Notice has been served.
and 2.
Neither AD card nor unserved notice has been returned till date with regard to respondent number 1, 2, and 13.
Yes.
So thereafter any order?
Thereafter 7/8/24.
Again, this is also 7/8/24. 7/8/24.
7/8/24 Lozima court's order
Okay, Lawazima court's order.
that shows services
Notice
complete.
has been received back answer with postal remark. 1113, no AD card has unserved notice has been received. 1415 notice has been received back answer with the postal remark, no such person. It appears that processor has been received from the office as per. So 1, 2, and 13 notice has been served to 1, 2, and 13.
1, 2, and 1, 3. Yes.
1, 1, 1, 4, and 1, 5. notice
1114
has been received by their brother. So service is complete.
That's why it has
So
been.
you want to place your submission for condonation of delay
Yes.
because they are not appearing after service of notice.
Yes,
Now today you'll place 1098 days, huh?
I can, your lordship.
Okay.
Lordship will find that after filing of this delay condonation in the second appeal, uh, in IA 1405 of 2022, by office note dated 16/8/2022, we have come to know that the addressee has expired. So that was the date of knowledge.
When?
16/8/2022. In IA 1405 of 2022.
Order dated
Office note dated 16/8/2022.
in IA number
In IA 1405 of 2022
1405.
of 2022.
Okay.
That is the delay condonation in the CRP, the revision petition. So there, this office note has shown that unserved notice upon respondent one has returned back with postal remark as addressee expired.
Okay.
So thereafter, we inform this thing to the petitioners, and the petitioners have given us the details of the legal errors on 11/11/2022. Wherein it was stated that the respondent expired on 1/1/2018. So thereafter, we have taken steps accordingly, and
1/1/2000.
1/1/2018. So thereafter, we took steps and filed this application on application. In the beginning of 2023, we filed this application for the delay on the substitution.
We will get the date. Anything else?
So that is not a negligence on our part, because we have only come to know about the expiry of the addressee on 16/8/2022. So it should have been counted from that day.
Then what will the delay be?
Delay will be 1829 days.
One.
1829. 8297.
Anything else?
No, this much of it.
I think this is a delay or inexplicable delay.
But your lordship, as it can be seen that we did not have any fault.
182 days, it's inexplicable delay.
Otherwise, your lordship,
How can you explain the other part? You have learned about the death of respondent number 1
yes,
on so and so date.
yes.
Then
That
before
also from
that,
the before that we are not knowing about.
So now when you have counted those days,
Yes.
you have counted from the
From the
date of knowledge,
date of the death.
date of death.
Date of death, that is 1/1/2018.
Okay, from date of death, it's okay.
So from the date of that, this 1829 days.
And from the date of death, this condonation delay is only from the date of death.
Yes, yes.
Okay, then there is no negligence.
So that is only my submission.
Okay, please read the application.
The relevant portion will be para 3, page 6. I'll read from there.
Page 6.
Page 6 of this IA 297 of 23.
Yes.
Your petitioners beg to state that initially the IA 1405/2022 in CRP number para 3.
Yes, yes.
the IAC 1405 2022 in CRP number 5154 2022 was filed in the name of Tikendra Chandra Singha as sole respondent number 1. And when the matter came up for orders on 22/8/2022 before the Honorable Court, the council, on going through the court's record, came to know. Here we have clearly stated that as per the office note dated 16/8/2022, unserved notice upon respondent number 1 returned back with postal remark addressee expired. The council took time for filing substitution petition for substituting the legal successor of the deceased. That the council thereafter requested the petitioners to furnish them with the name and details of the legal heirs of the deceased. The petitioner furnished the same along with the details of the legal heirs of the deceased on 11/11/2022 to the
That is
council.
after 3 months.
After 3 months.
So there is a delay on that part also, 3 months delay.
That is negligible, Your Lordship.
Okay.
To the council, along with the death certificate of the respondent, late Tikendra Chandra Singha, who expired on 1/1/2018. So it is from this date that this delay has been calculated. That the council thereafter prepared the substitution petition, then sent the petition to the petitioners to get them signed on 18/11. The council received the signed petition from the petitioner on 16/12. So here also there is a delay. And in that event,
So then the delay got extended up to from that date of death.
from that, yes, for counting in regard to this 1829.
From the date of death, no, from the date of knowledge, that is 16/8 to then 4 months, 4 months.
Yes, from the date of knowledge, it will be 4 months. And in that event, there occurred an inadvertent delay of 1829 days in filing the petition for substitution of the legal heir of the deceased. That the petitioners could come to know about first time about the expiry of Tikendra Chandra Singha only when the council of the petitioners intimated them that from office note dated 16/8/22, they could come to know that Tikendra Singh expired. Petitioners collected the details of the name of the legal heirs on 11/11/22 and furnished the same to their council. The delay occurred is not due to the fault of the petitioners, but due to the fact that the petitioners did not have any information about the death of Tikendra Chandra Singha. Although on record there is a delay of 1829 days. However, since the petitioner would come to know about the death of Tikendra only on 2/9/22, when the council of the petitioner intimated the petitioner about the death of Tikendra Chandra Singha, and as such the delay occurred, is negligible. Therefore, the prayer on the next page, that under the aforementioned premise
Okay,
that
okay.
is,
So
and
you first came to know about the death on when you were filing the original CRP.
original CRP along with the delay condonation. I think there is
along
a
with the
delay.
Condonation. What is the delay condonation application number?
1405 of 2022.
Okay.
Ten 123. No? अच्छा, अच्छा. बोला गया. 10,
On 28th April 2022, you have filed a CRP.
28th April 2026. And Your Lordship, I will also.
And this delay condonation petition you have filed on. Just. Hmm. 12 May 2022.
12 May 22. Thereafter, I think the matter was listed before the court, before the Honorable Court. Thereafter, the said matter was listed before the Honorable Court.
But why is the notice stamp marked as 25/5/2023?
I think it should have been 22 because the this filing number and the IA number also indicates 2022. And the order order which we
You
have challenged.
check why is the notary stamp marked as 22/5/2023?
No, I,
Filing number is 12, filing date is 12 May 2022,
yes,
but the notary stamp. From where did you get this notary stamp marked as 22/5/2023?
probably there will be some mistake, I think some mistake, because the registration date is 22 of both the CRP as well as the IA. How,
Yes, 2022, but the IA number you have stated 1405.
yes,
IA was filed on another date, 12 May.
12 May.
But the CRB was filed on, CRB definitely will come later.
Yes.
After delay, I think delay has been condoned.
I think both have been filed together only. Initially the IA comes up for
Yes, yes,
condonation of
that is
delay.
why it came up later, CRP, it's okay.
Yes.
I understand, but.
And the IA, in the
you
IA, I
may
think,
check the notary's stamp. Or else you may take instructions later and come back to me some other date, you check the notary's stamp. Okay?
okay.
এইটো অকমান দেখাই দিবা তেখেতক এইটো ইয়াতে লগাই থৈ দিব
This
when
IA,
should I fix it? Tomorrow, day after tomorrow? Not tomorrow, day after tomorrow,
then next week.
next week.
Your Lordship, this IA has been filed on 10/1/23. This
10/1?
10/1/23. This delay on the substitution, this 297.
No,
So-
not this, not this.
No, so those
This,
cases.
not 297.
Yes, yes. The cases
right.
prior, yes, yes. That will be
There are
obviously.
differences in dates,
Mm.
filing and the notary stamp. You just check next week,
Next week.
check and then you can explain. Our learned counsel, Mr. S. Doctor, for the petitioner, who has stated that the service of notice on the newly implemented respondents is complete. The Lawazima court's order dated 7/8/2024 reflects that services of notice on respondent number R1 to R5 is complete. List the matter on next week. You want a date?
Any date next week. Obliged.
16.
But this contempt petition is filed against the action of the respondent club. While they lodged an FIR against me on 7/7/2023, there was an order passed in the first appeal filed by us as an interim protection, and it was a direction given by this court that no coercive action to be taken against the petitioner herein. That first appeal against order has been disposed of with the same direction. It has been remanded back to the trial court, and the issue is pending there. But till the decision comes up in the injunction application, the interim protection granted by this honorable court was allowed to be continued till the order. So if I may take your lordship to the order passed by this honorable court at page 11 on 23/9/2022. The lordship has got
Page 11.
page 11. Starts from page 11. Page 11 of the contempt case. This interlocutory application was filed under Order 39 Rule 1 and 2 of the CPC for grant of ad interim temporary injunction restricting the opposite parties from taking any coercive action, including expulsion of membership of the petitioner from India Club in the upcoming extraordinary general meeting to be held on 25/9/2022. In the next page, the last para. Having heard the learned counsel for the petitioner and considering the fact that the general meeting and the extraordinary general meeting is scheduled to be held on 25/9/2022, this court finds it fit to pass ad interim temporary injunction restricting the opposite parties from taking any coercive action, including expulsion of the membership of the petitioner from India Club till the next returnable date. So mistakenly, by this order, the interlocutory application was disposed of. So thereafter, we filed a review petition on the ground that the order passed by this court to the effect of disposal of the interlocutory application was not correct. And that's why in the review order, that part of the order was modified, which your lordship will find at page 17. Paragraph 9. Accordingly, the order dated 21/9/2022 is modified and clarified by deleting the words interlocutory application stands disposed. Accordingly, the last paragraph of the order shall read as follows. Issue notice upon the opposite parties through registered post with AD wherein the petitioner is to take necessary steps. So by the review application, we sought for a clarification that the interlocutory application which was disposed of ought not to have been disposed of. To that effect, this order was modified. But so far as the interlocutory ad interim injunction granted in my favor was concerned, it was as it was maintained. Thereafter, finally the first appeal against the order was heard, and this honorable court, the coordinate bench of this honorable court, found it appropriate to remand it back to the learned trial court, where the suit is pending. The facts of the case is like this: the petitioner herein wanted to participate in the election to be conducted by the India Club for the post of joint secretary. Joint secretary of the club. At the time of filing nomination paper, I submitted some documents. Along with the application, I submitted the qualification certificate also, the degree first year, second year, and third year mark sheets. So somehow during verification, the degree third year mark sheet was not found to be genuine. So the returning officer asked me to submit the original copy of the mark sheet. So it was the allegation by the club that at that point of time, I raised hue and cry. I tore up the documents therein. I threw all the documents in front of the office bearer, etc. With that allegation, a complaint was lodged and a club committee took action as per Article 10 of the Constitution of the club. I was suspended for 6 months from the club. Thereafter, I filed an appeal before the executive committee that my suspension was reduced to 2 months. Thereafter, to the General Council, I filed a review petition. The suspension order was reduced to 1 month. After all these things happened, the RO, returning officer, lodged a complaint before the General Secretary of the club, saying that the document I submitted before at the time of filing nomination paper was not genuine. On that ground, club committee thought it appropriate to issue show cause notice, and thereafter, after in-house inquiry, they decided to take up the extraordinary meeting in the General Council to decide the fate of the allegation leveled against me. So I challenged that particular action of the club by way of filing a suit which is pending for a decree declaring that the action taken by the club committee to call an extraordinary meeting in the General Council is contrary to the provision of Article 10 of the club committee, Constitution of the club. So the fate of the suit will be decided later. In the meantime, they lodged this FIR during the pendency of the case as well as the prevailing injunction order granted against me, which your lordship will find at page 18.
Okay.
If I may read, my lord.
Yes.
The India Club Executive Committee elections 2022 were supposed to be held in June 2022 and our club member, Mr. Binod Das, applied for the post of joint secretary and submitted his nomination papers with copies if these mark sheets, academic certificates as mandated by the club constitution. The returning officer of the ensuing elections called upon Mr. Binod Das, that is the petitioner hearing, to submit all original academic documents which reflect that he is a graduate as required by the club rules to contest the election. Mr. Binod Das again submitted the purported copies of his BCom Part 1 and Part 2 certificates, and the returning officer, as duty bound regarding the genuineness of the same, asked Mr. Das for the originals, on which Mr. Das got extremely agitated and lost his temper and also snatched away his submitted papers and destroyed them. That the returning officer, India Club Executive Committee Elections 2022, communicated with the controller of examinations, Guwahati University, asking for the verification of BCom Part 1 and Part 2 examination, 1996, certificates of Mr. Binod Das. In response to the said communication, the controller of examinations sent the letter dated 9/8/2022 by reference number so-and-so to the returning officer stating that,
Okay, yes.
well, your lordship will see, with the same facts, with the same allegations, the FIR is lodged at the point when there is an injunction or order
Yes.
in my favor. So the order says no coercive action to be taken. Well, had there been any other allegation, like any other criminal act committed by the petitioner, the question would have been completely different. But the FIR is lodged with the same set of facts, with the same set of allegations, which is the subject matter of the suit pending before the court. And by perusing all the materials, this honorable court was pleased to direct the parties not to refrain from taking any coercive action against the petitioner. Well, by this FIR, though there is no cognizable offense in my humble submission, and at the first instance, the FIR was, they are the police authorities were reluctant to register the FIR in fact. But my client was called there twice, thrice, sought for explanation out of the pressure created by the club. Well, these are the unnecessary harassment being committed, and this indulgence been not to be given to the club. Well, by every now and then, if the club raises any allegation with the same set of facts and some sort of harassment is caused to be made against the petitioner, this will be contrary to the order passed by this honorable
Is this
court.
fixed for orders or hearing? Orders, no? Okay. All right. Yes.
But this is only my humble, my limited prayer is, the club may be directed to refrain from doing anything contrary to the order passed by this honorable court, not to take any coercive action further, because this FIR, ipso facto, prima facie shows that the allegations in the FIR are the same set of allegations which were made during the time of election, and for which punishment was awarded against me. For the second allegation, the suit is pending. Extraordinary meeting was supposed to be called for because of the stay order, injunction order passed by this honorable court, and subsequently which is pending.
Just a moment, this pleadings are complete.
Well, they have filed a affidavit of opposition.
So we'll take it up for admission then, hearing and admission. We'll take it up for hearing. Or today we'll place your hearing, today itself.
We are ready. This
Ready?
is not, it is absolutely nothing, my lord. This is
You
an
have
abuse of
completed.
the contempt jurisdiction.
Completed.
Yes, my lord. Well, I have a limited prayer, limited submission. This suit is pending. I just pray before this honorable court with the direction to the respondent authority not to take any further coercive action and to comply the order passed by this honorable court. That's all, my lord. With this direction, your lordship may dispose of the matter.
In a contempt, if I am found guilty, I'll go to jail. Where is the question of further direction? If I am guilty of contempt, I'll go to jail. Where is the question of further direction in a contempt petition? This is an absolute abuse of the process. Your lordship will decide how much cost your lordship will impose on the petition. The facts, if the allegations are the same in the FIR as in the suit, he should have filed a petition for quashing of the FIR. Why doesn't he file the petition? The logic is very simple, my lord. He has committed such serious forgery and fraud. This is, my lord, we are talking about one of the oldest clubs of Assam, India Club. He wants to contest as a joint secretary. He submits for, he is not even a graduate. He represents that I am because one of the conditions for contesting election is that you have to be a graduate. He submits forged certificate, wants to contest, when the returning officer found that there is something wrong with the certificate, he asks him to produce the original. When he's cornered, he tears off all these documents and throws it away. Thereafter, we write to the Guwahati University. Guwahati University tells us that these are forged certificates. And he says that because there is a suit pending and your lordship has directed that no coercive action should be taken, we are prevented from lodging an FIR. He commits a criminal offense and we are simply lodging an FIR. Can that amount to a coercive action? So therefore, my lord, your lordship will not entertain such petitions and impose exemplary caution, not less than 1 lakh rupees, my lord. I am saying this with all sense of responsibility. There is a limit to abusing the judicial process. There is a limit to misusing and wasting the judicial time.
You are filing this case.
My lord, I am ready to pay
This
the
petition
exemplary, my
under
lord.
which section? Civil contempt, criminal,
Yes,
criminal
contempt.
contempt.
Yes. Well, if your lordship finds the allegation made in the
Contempt of
contempt
court section
application
42.
and the contents of the FIR, my lord.
Where is the petition? Just a moment. Yes, yes, please carry on. Yes.
Yes.
Hmm.
My lord, if your lordship finds from the contents of the FIR
Hmm.
and the allegation made in the, my lord, the other connected suit and the first appeal, which was remanded back by this honorable court, and if it is a submission of the learned senior counsel that there is no contempt, my lord, I fail to understand what is the meaning of coercive action, my lord. My lord, when the court has specifically ordered, pass an order, the judicial order, my lord, against the club not to take any coercive action, my lord, had there been any criminal offense committed by the petitioner, the question would have been completely different. My lord, dacoity, theft, any other criminal case, there is no bar under the law, my lord. 154 doesn't bar anyone from lodging FIR. But when the FIR is lodged on the same set of facts, on the same allegation by the returning officer, which has nothing to do with the, after the election is over, which has nothing to do with the allegation made in the, whatever allegation is made and the inquiry is conducted. And the certificate, my lord, who is there, my lord, alleging that this is not the genuine certificate. My lord, I withdrew my nomination paper. I withdrew myself from the nomination.
Your lordship will ask him whether he is a graduate first.
Well, I may not be graduate, but I'm not contesting the election. But the contesting election with the forged certificate is a different thing. Withdrawing from the nomination, my lord, contesting the election is a different issue. Had I my lord, contested the election with the forged certificate, with a belief, making the officer to believe the certificate to be genuine, that would have come under the fourth corner of, my lord, forgery. But when, at the first instance, when the original certificate was asked from me, I withdraw my nomination paper from the returning officer. Does it amount to any offense, my lord? Well, offense, it should go to the root of the offense, my lord. Well, had I submitted the application along with the documents, making the authority to believe the forged document to be genuine, and I contested the election, and subsequently, my lord, whatever the result may be, then, my lord, the question would have come whether I committed forgery or not. When at the first instance, when the authority asked me
Just a moment.
to submit.
See, that document, that a criminal case has not been registered.
Exactly.
So, but the document according to you is a forged document.
Yes,
Certificate, he is not a graduate.
He has used the forged document as genuine matter before 71. How he has said that it's not a criminal offense? A person knowingly using a document which appears to be forged one, admittedly forged one, we have a duty bound, matter the university on our request has given that this is a forged document. And he has used, admittedly, he has used that document by filing the nomination paper. That means what?
But where is the urgency to file an FIR immediately when there was an order in
No,
force?
this is not immediately, madam. After the AGM, there's a decision was taken by the AGM that because he has used the forged document and there is nothing which no court can restrain, my lord, a statutory prescription, madam.
can the court restrain a person not to file an FIR, my lord, if there is a cognizable offense?
No, there was an order.
No, that order is very.
Stay order.
No, Lordship, kindly see the order. Order is very different. Not to take coercive action, that means what? Not to suspend him. Can the order, that can be in a pass by this court, my lord. The superior court also debarred. It cannot, my lord, it can't be. And the civil court, as long as the criminal court, the proceeding can go simultaneously. There are captain of judgment, my lord. The same thing. There may be a civil offense, civil liabilities as well as the criminal liabilities in the same offense, my lord. Same cause of action, my lord. In that case, my lord, when he has filed the document, admittedly, a forged document for the purpose of appearing in the election, my lord. This is a 471, a cognizable offense. So definitely we have to take an offense, my lord. Where there is an offense, prima facie appears, how we can be debarred by a superior court also. There's a judgment. Even the superior court cannot damage, my lord, for lodging the FIR. Can it be blanket
Depends
order?
upon the seriousness of the offense.
Yes. Well, can the superior court?
Depends upon the seriousness of the
Yes,
offense.
yes, but this is a serious offense, my lord. Using a forged document for the appearing in the club, and there is no restraint with it. Lordship, kindly see the order passed by this honorable court. What is the restraint, my lord? The page 11, Lordship, kindly see. There is no restraint, my lord, by this court. What was he asking for, my lord? Not to take any coercive action. Does it mean and hold? Page 12, my lord. Page 12. Having heard the learned counsel of the petitioner and considering the fact of the general meeting and the extraordinary general meeting, it is scheduled to be held. So, this is 4 days prior to the general meeting. This court finds it fit to pass an temporary injunction restraining the opposite parties from taking any coercive
Okay, all right.
including expulsion of the membership of the
Okay.
petitioner
All right,
from
all right.
India Club and the next day returnable there.
Understand specific, only relating to expulsion of the person.
Yes, apart from that, my lord, no court cannot direct anyone if there is a cognizable offense has been made out not to file an FIR. I'm flabbergasted by the submission made by that there is already a civil case. The civil court as well as the criminal, the same cause of action, out of the same cause of action, there may be criminal liability as well as the civil liability. And the both can go together. If there is no cause of action, as he stated, there is no quashing at all. Where is the quashing petition, my lord, for the?
The case is not registered, my lord. What to quash?
Then
There is nothing to be quashed.
So if there's cases has not registered, my lord, then where
But
is
I was
coercive
told-
action? And he says if there's no cases has been registered, where is the coercive action? Simply filing of the FIR, does it mean any coercive action we have taken, my lord? That means, what is the, so I can't go.
My lord, I had to
If-
visit the police station thrice. What
That
does
is
it mean?
that is
My lord, these are
that
the
is-
coercive action.
so you have not made the party, the police is not the party here. So if there is a contempt, the police has without any registration of the case, if the police is asking for, and he has to cooperate with that because of the inquiry also. Because the CRPC, before there is an inquiry can be done prior to then, and during the inquiry, he is bound to cooperate with the investigation. He cannot claim that I cannot be called up in the This is an outrageous proposition, my lord. How can it be, my lord?
You have submitted an objection, written objection?
Yes, my lord.
Where is?
We will file a whole affidavit, my lord.
I am here for 4, 5 and 5, 4, 5 and 6.
And then anybody is asking for exemplary cause also, exemplary cause?
Yes, we are asking for, my lord, exemplary because this kind of petition, my lord, it should be, my lord, definitely. How can they ask for, my lord?
My lord, if my petition found to be frivolous, my lord, I'm ready to pay twice the cost, my lord, they are asking.
Yes,
My lord, the exemplary cost, my lord, what they are asking. My lord, the coercive action, what does it mean? My lord, if I may read the FIR, if I may read the order, page 12, my lord.
My lord, lordship.
You don't preempt. I'm not going that way.
No, I'm not saying that. The submission made by the Learned Senior Counsel are but contrary to the, my lord, provision of law, my lord. Exemplary cause is not the, my lord, food to be, my lord.
My lord, let him simply say that simply show us that the court, if there is a cognizable offense, even let him show that even there is a cognizable offense, court can restrain a person from giving up a FIR, my lord.
My lord,
If
provided it
that
is
is
a
the law,
cognizable
my
offense.
lord, yes, this is a cognizable.
My lord, provided this is a
Yes,
cognizable offense.
let us read what is the cognizable offense, my lord. Let us read.
What is cognizable? Well, let us read the FIR. If this is not cognizable offense, what is? The using a forged document knowingly and then he is withdrawing, then why you have withdrawn?
I
Then
did
why
not
you have
derive
withdrawn,
any
brother?
benefit out of the document
No,
and I
that's
have
a different
submitted.
issue.
And
Whether he has,
document, my lord,
you
there
have,
is no
you-
declaration to the receiver.
he has entered into the house, my lord, now he has entered in, he has coerced, he has, my lord, trespassed in the house, but he has failed to commit the theft. Now he says, I have not committed the theft, so I may be excused for the trespassing, my lord. Is it a law, my lord?
This example will not hold good, my lord. Trespass. for
Let us,
trespassing,
let me
I
submit,
need to
let me,
break,
sir,
my
you
lord.
take your seat, let me submit first, my lord.
Well, I have not completed my submission.
Then complete your submission first.
If I may read the order, my lord, page 12.
Page 12 I have read.
No, my lord. Page 12, my lord, there is a line, my lord. It says, this court finds it fit to pass ad interim temporary injunction restraining the opposite parties.
Just a moment, just a moment. Yes. Please read it.
This court finds it fit to pass ad interim temporary injunction restraining the opposite parties from taking any coercive action, including expulsion.
Okay.
It doesn't say it relates to expulsion.
Okay, okay, I
It
got
says
your
about
point. Yes,
any coercive action.
I got your point. Yes.
My lord, section 154 defines, my lord, the FIR, fast information, my lord, cognizable offense. But the first information was obtained by the office in the year 2022 regarding forged document. This FIR was lodged in the year 2023. That too when the case is pending, there is an interim injunction in my favor. Well, if the interpretation of coercive action is such, it should relate to the subject matter of the suit. What is the subject matter? A extraordinary meeting was called for in a general council to decide the fate of my membership in the India Club. And I challenge that provision, saying that Article 10 of the Constitution doesn't have the power. There are other ways. The sequences, the hierarchy should be maintained. The suit, my lord, it is pending for decision. Whether it comes in my favor or not, it's a different issue. But in the meantime, the FIR was lost in the year 2023. The first cognizable offense, this is the first information. Had there been any forgery at the first instance, the returning officer or any member of the club would have lodged an FIR. If it is so serious, why did the police not register the FIR? Why I was called there in the police station thrice? Well, as a citizen, nobody wants to go to police station. Well, cooperating with the investigation is different thing. Had there been any other criminal offense committed by me, anything like the example given by the learned senior counsel like trespass, very well, there is a power under section 154 CRPC to lodge an FIR, different subject matter. Had I committed murder? No. These are allegations. These are allegations, my lord. So there is no such offense. The offense narrated in the FIR is the allegation with which, my lord, the suit is filed. The meeting was called for, and with the same set of allegation, FIR is lodged. Well, if a person has to go to a police station thrice for the sake of some talk, my lord, discussion, and that too out of the pressure created by the other members, the authorities of the club.
That meeting was firstly initiated in 2022.
22.
That what is this called? Election meeting.
Election means notification was issued calling upon the nomination from the member for the post of joint secretary. I tried to participate. Somehow, I don't know, there is no declaration from any court that the documents, my lord, which I submitted, the third year mark sheet, is not genuine.
Okay, what is your prayer here?
Well, prayer, my lord, I simply asking to restrain the club from committing any such, my lord, action, from taking any such coercive action, because there is already a judicial order passed by this honorable court.
Okay, but then your expulsion time was reduced also, no, to 1 month?
That punishment, my lord, I served.
That is a different.
That's a
that is
different issue.
Different issue, my lord.
That I served.
Their issue is the lodging of the FIR itself, my lord.
Below this.
The lodging, their contention is the lodging of the FIR, it's a violation of the order passed by this honorable court. Because there is a restraint. Our contention is totally different, my lord. Because the CRPC also says, I'll show, my lord, let him complete, my lord.
Well, I am not asking for much, my lord. Well, CRPC says, my lord, one
I'll
to
show, my
report, my lord, who can lodge FIR and to what extent the allegations are, my lord.
Then,
My lord, these allegations are made on the basis of the same set of facts for the mark sheet I submitted, which I subsequently withdrew. My lord, to declare a document to be forged, my lord, there must be some judicial declaration. Only saying that a document is not proof, it's genuine, my lord. My lord, we cannot give the evidence. We cannot prove the document that this is genuine, this is forged.
that is the purpose of investigation.
So this
That's
is
why
not the
FIR
purpose of the investigation. My lord, investigation could have happened had the FIR been registered. But
So this is
23, the
your
FIR
prayer
was lost. This is 25.
Portion is not,
My lord,
your prayer portion is not similar to your submission. That's what I'm saying.
Exactly.
your lordship has the power to mold the relief, my lord.
Not in the contempt.
My lord, I prayed for being shown and on hearing the parties be pleased to pass appropriate order for punishment of the contemptor for deliberate disobedience of the order dated passed by the so and so. Yes, my lord, this is what the contempt jurisdiction for punishment. But your
But
lordship
now
may,
you
your
submitted
lordship,
that you, that,
your
not
lordship
doing
may
coercive
modify
action
the
against-
relief. Your lordship, as per the facts and circumstances of the case, my lord, your lordship may modify.
My lord, this is, that can be.
Then your lordship may issue an order punishing the, my lord, hiring official, lodging the FIR. But because the lodging of the FIR itself goes to show that there is a process, my lord, there is an attempt to circumvent the order passed by this honorable court, and it was a judicial order.
Now, my
So
lord,
you are sticking to your prayer now.
Your lordship may modify. There is no, I will concede. There is no there because this is the my lord, prayer generally has to be made in the contempt case, and that's why I made this prayer. Otherwise, I will concede. Your lordship may modify the relief.
now lordship kindly see now he says that this is not a cognizable offense, my lord.
No, it is a cognizable offense.
Then if
According to, according to the allegation, it is a cognizable
Then
offense.
if it is a cognizable offense, my lord, can any person can be debarred even by the court to not lodge an FIR, my lord? Because the CRPC says otherwise. Even in the CRPC, there is a provision, very specific provision. If I see an offense has been committed, it is a duty to me to lodge the FIR. If I don't lodge the FIR, then also I have committed an offense, my lord. It's the other way around. This is the CRPC says. If I see an offense, even a bystander, if I see an offense,
It is there. It is
If-
there in the CRPC.
yes, if I don't lodge an FIR, it is rather an offense against me, my lord. That knowing by seeing the offense, I have not lost the FIR. That here what happened, my lord? The returning officer intimated the club officials that he has tried to commit an offense because during the process, he submitted a false document, which appears to be a false, and he has used the false document 471. And 471 is a cognizable offense, my lord. So accordingly, we lost the FIR. And what is the coercive action, my lord? Coercive action generally taken by the, my lord, the police regarding the offense, not to arrest. These are the coercive action. We are simply lost, we are grievances. If I put my grievances before the authority concerned, and this is the police is a authority concerned, my lord. Police is who will investigate, my lord. We are not investigating. We are not punishing him, my lord. We are not taking any coercive action against him. Lodging of an FIR, can it be a coercive action, my lord? If he can show that the lodging of an FIR is an amount of coercive action, my lord, in each and every cases, my lord, the lordship knows it very well, my lord. In all the 482 petition, my lord, lordship passes a not to pass any coercive action. Against whom, my lord? Not to arrest, not to harass, to the petitioner. But lordship cannot say that the FIR will be quashed. under 482, not to take any coercive. No, that's not the law. Law is that the investigating authority, because they are the authority concerned, and this is the prima facie is a cognizable offense. And we are bound to register an offense. We have just intimated. And it is up to the police officials whether they register it, investigate it, file the search it. That is up to the authority concerned. So we are debarred to go to an authority for an cognizable offense. Is it a law, my lord? Is it a direction of this honorable court? This is not a blanket order against him, my lord. This is connected to what? And he says that he was called for. In the petition, there is nothing. In the police has called for twice and thrice. In the petition, it is absolutely silent. It's simply his argument. And the lordship kindly see the page 18, the FIR. Along with the FIR, we have, and he says that this is not a cognizable offense, my lord. And my humble understanding of the law, my lord, civil cases and criminal cases for the same cause of action can run simultaneously. If there is a criminal proceeding out of the same cause of action as well as the civil liabilities. For that, it cannot be quashed. And as he has submitted that it will be decided then why he has not come up for the quashing of the FIR? And the lordship kindly see our affidavit, my lord. 1, 2 and 3.
1, 2 and 3, yes.
Page 111, my lord. The verification of the mark sheet of the Binod Das. With reference to subject cited above, I would like to state that regarding the matter of the application submitted by the Controller of Examination Guwahati on so-and-so, asking final verification the mark sheet so-and-so, bearing the roll number so-and-so. Now this is 22, my lord. The application approached the Office of the Controller Examination Guwahati University for verification of authenticated the mark sheet, which was verified by the person of the confidential one, and reported that the name in the mark sheet not match with the original merit register available in the confidential custody, Guwahati University. Hence, it appeared is a 4th mark sheet, my lord. So after this, my lord, when I received this, my lord, so definitely, my lord, and he has, and our FIR is very specific, my lord. And now, lordship kindly see the page 18. The India Club Executive Committee election 2022 was supposed to be held at so. Our club member Binod Das has applied for the post of Joint Secretary Sports and submitted that his nomination papers with copies of the mark sheet, academic certificate as mentioned in the club constitution. The returning officer of the ensuing election called Mr. Binod Das to submit all original academic documents which reflect as he is a graduate as required by the club rules and contest the election. The Binod Das again submitted the purported copies of the BCom Part 1 and Part 2 certificate, and the returning officer of the duty bound regarding the genuineness of this same asked Mr. Das for the original, and which Mr. Binod Das got extremely agitated and lost his temper and also snatched away his submitted paper and destroyed them. That the returning officer Guwahati so-and-so communicated the Controller of Examination Guwahati asking the verification of the BCom Part 1 and Part 2 examination 1996 certificate of Mr. Binod Das. In response to the state communication that the Controller of Examination sent the letter dated so-and-so by reference number so-and-so, returning officer stating that the name in the mark sheet does not match the original merit register available in the confidential custody of Guwahati University, and it appears to be forged mark sheet. In the light of the above facts, it now appears that there are some discrepancies and illegality exists vis-a-vis the academic certificate of Mr. Vinod Das. I being law-abiding citizen and capacity as an officer of this prestigious club, therefore requested to investigate the matter and take necessary action as per law. So as per law, we have asked for, we have approached the authority concerned with an FIR. If that is the debarred, we cannot go even for a cognizable offense, my lord. Then I can't, my lord, believe that when the offense has been committed, prima facie, my lord, and we can be debarred to file even an FIR. And where is and there's no blanket. There cannot be blanket order. Lordship, kindly remember one thing. When the court can pass a blanket order against when suppose when I come up for an anticipatory bail, my lord. Suppose no case is registered, we come up with there's an apprehension of my arrest. I come before a lordship, my lord, with an apprehension that there may be a case against me, so I may be protected. Can lordship pass a blanket order that they know he cannot be arrested without giving the case number, my lord? There cannot be any blanket order. There has to be. That's why lordship always calls for any report from the particular police officer. Is there any cases pending? Is there a specific allegation against him? Because there cannot be any blanket order not to arrest. There can be, my lord. So if there is a commission of the offense, so we are bound by the law to register an FIR, to submit an FIR before the authority concerned. And if tomorrow, if it is a frivolous complaint, then definitely he has a recourse for.
It has not been registered so far.
That's why I'm saying, but so if it is not registered also, that's a different issue altogether. But our case is that the filing of an FIR can be termed as a coercive action, my lord, by the club, where there is no specific direction. Even my humble submission, I'll submit even the superior court cannot specifically direct not to register an FIR. That's right, is a statutory right if there is a cognizable offense is made up. Everyone can go and file an FIR, my lord. If I'm aggrieved by that, then the court can stop that you cannot. So for that, any kind of offense, suppose that for that, let us take it that there's an injunction in his favor. So if he commits an offense tomorrow in the club premises, some other offenses also, can he come with an allegation? Come with that there's a bar? That is what has happened, my lord. His submission is that there's a blanket order in my favor not to take any coercive action. So even you can't even file an FIR. That can't be, my lord. That's an outrageous proposition, my lord. If that is accepted, my lord. When there is a prima facie, there is an offense, my lord. When there is a prima facie offense has been committed, we are bound even by the CRPC itself. How that prescription can be taken into account? Other way around. When there is a specific in the statute provides that you are bound to inform if there is an offense has been committed. That is the prescription of the CRPC, my lord.
Okay.
Let my learned friend, my lord.
You have correspondence?
4, 5, and 6.
1, 2, and 3 we have heard, 4, 5, and 6. Okay. These are all members, executive members of the club.
My lord, number 1 was at that time the general secretary. The others are members. In fact,
So because you are Mizoram's advocate general, aren't you? Arunachal Pradesh.
Arunachal.
So I was wondering where you are appearing for any.
no, well, that is Arunachal.
Okay.
But if your lordship kindly comes to the order passed by this honorable court, page 12. My young friend here is trying to have your lordship interpret this order, this portion.
To read between the lines.
Having heard the learned
Yes.
counsel for the petitioner and considering the fact that the general meeting and the extraordinary general meeting is scheduled to be held on 25/9/22, this court finds it fit to pass an interim temporary injunction restraining the opposite parties from taking any coercive action, including expulsion. Now, he is trying to impress upon your lordship
Yes, yes.
that this word taking any coercive action
Yes.
will encompass anything. The club cannot do anything. That cannot be, because interim orders are always passed in the context of the case. At that time, relevant point of time, what was the case set up by him? His case was that there is a process initiated for expelling me from the club. In passing this interim order, your lordships, even by the wildest stretch of imagination, could not have meant that he will commit offenses and people will not even lodge an FIR. What is the meaning of lodging an FIR? It is a first information to the police that we feel that a criminal offense has been committed, kindly investigate. That cannot come within the meaning of coercive action. That is my first submission. Second submission is, if your lordship will kindly come to the petition. This is the case set up against us at page 6, my lord, paragraph 7. And based on this paragraph 7 and 8, a submission is sought to be made that this amounts to contempt. But if this would amount to contempt, the law will have to be rewritten. That the petitioner, up to paragraph 6, the petitioner describes about the order passed, thereafter paragraph 7. That the petitioner states that on 25/6/23, an annual general meeting of India Club was held. In the said meeting, by suppressing the agenda of the meeting from nowhere, Mr. Biswadip Bora, ex-general secretary of the club, proposed that an FIR should be filed against the petitioner. There is a general meeting going on. So Mr. Bora, Biswadip Bora, who is the respondent number 5 here, he proposed that there appears to be a criminal offense. So we should discuss whether we can lodge an FIR. That proposal was made by Biswadip Bora. Accordingly, all the other respondents supported that decision. So in a meeting, there is a discussion going on. Mr. Bora proposes FIR being lodged. Other respondents supported. However, some of the senior members of the club drew the attention of the club towards the stay order passed by this honorable court, but none of the members paid any respect to the orders, and the general secretary of the club lodged an FIR before Panvel Bazar police station. Now, what he does not say here is this is a discussion going on in a general meeting, and the decision to lodge an FIR had to be approved by the general body. Only then the FIR could have been filed. Now, where is the general body? Where are the other executive members, if at all it is coercive act? The reason is personal enmity against these 6 respondents. And he wanted to, at that initial point of time, perhaps he thought that let me teach you a lesson by taking you to court. But that is why I said, you cannot use the court to abuse the judicial process. You cannot waste valuable judicial time in the name of frivolous petitions like this. So, to now say that I am conceding, let there be a further direction. There is no question of any further direction in a contempt petition. Your lordship can record my submission. If I am guilty of contempt, I will go to jail. That is the only thing in a contempt jurisdiction that this honorable court can do. So, to now try and show magnanimity that I am conceding, let there be a further direction. He is now trying to, basically he knows that he is cornered. What he has done, the extent of, we did not go to that extent, since he is a fellow member. What he has done is, he has taken, let us say, Anshuman Bora's mark sheet, forged it, put my name, Indranil Chaudhary, and submitted it to show that I am a graduate, so that he can contest the election. Is it not forgery? All that will come out. We are not going into such details, since that is not within the purview of the contempt jurisdiction. A lot will come out. He wants to basically prevent, threaten. Contempt jurisdiction cannot be used like this. This amounts to an abuse of the judicial process. And therefore, I said that Your lordships will not allow such frivolous petitions to be filed, wasting valuable judicial time. Why hasn't the submissions made are submissions to be made in a quashing petition, not in a contempt petition. If it is the same set of facts, if no case is made out, your lordship will quash it in an appropriate proceeding. Not in a contempt. Contempt is your only thing that your lordship will see is there a specific direction? Has that direction been violated? If it is violated, if it is willful and deliberate,
Yes.
even if the Supreme Court has time and again said that even if there is a question of interpretation is involved and an order can be interpreted in two different ways, even then it would not amount to contempt. So therefore, my lord, in my respectful submission, your lordship will not only dismiss this petition, your lordship will set an example by imposing cost. And there is no question of any further direction. In a contempt jurisdiction, that cannot even lie in the mouth of the petitioner. The petitioners, in fact, once a matter is brought in a contempt before this honorable court, it is, Supreme Court has time and again said that it is between the court and the contemnor. He can simply say that there is an order that has been violated. Now he has to show that coercive action in the context of a civil suit will mean and include lodging or not lodging of an FIR. That is a question of law. He has to satisfy your lordship. Otherwise, there is no scope, my lord, in this. With greatest respect, with all sense of responsibility, I am making this submission. Your lordship should not allow this court to be used like this. That's all.
You want to reply?
Yes, my lord. Well, I will borrow some of the submissions made by the Learned Senior Counsel. One of the submission made by Learned Senior Counsel, my lord, was that is there any order, blanket order, not to take any action against the petitioner had he committed any offense inside the premises of the India Club, if I have understood correctly. My lord, I have, at the foremost, I have submitted at the beginning of my submission, had there been any other offense, any criminal offense, well, there is a provision under the CRPC and there is a right also given to the person to lodge an FIR before the police, showing that this is the cognizable offense being committed by the petitioner. Anything. What I am on, well, so far as the contents of the FIR is concerned, from where these contents has come, well, these are the allegations which my lord evoked during the election time. Two incidents occurred. One is misbehavior, for which I was given the punishment, subsequently reduced to 1 month. Second set of allegation, forgery of documents. My lord, against that, a formal complaint was lodged by the returning officer. After the election notification period was over, he had no business thereafter, my lord. After the election period is over, the returning officer does not have any business to lodge any complaint against a person, my lord, who submitted some documents which was alleged to be forged. Later on, he withdrew his nomination from the election. He did not derive any benefit out of any documents submitted, making the authority to believe that these are the genuine documents, because the first moment when he was asked to submit the original document, he has withdrawn his nomination paper. He did not pressurize that this is the genuine document I have submitted and this is not forged.
Okay.
So far as the repeated submission of the Learned Senior Counsels, my lord, regarding the subject matter, why not quashing? Well, quashing, my lord, in my humble understanding, my lord, once the FIR is registered, my lord, there is a question of filing quashing petition under section 482. Now the BNSS law has changed. Since the FIR, since the year 2023, not been registered, the question of filing quashing petition, my lord, does not arise here.
Even that statement is not made in the contempt petition, that it has not been registered. That is why he has filed the contempt. Your lordship will kindly peruse. There is no statement in the petition. These are all oral submissions being made. I don't know from where.
My lord,
All sorts of oral submissions being made. I am conceding, no FIR registered. I am called to the police station 2-3 times. Where are these pleadings? This is, don't convert this into a circus. Please confine to your pleadings.
my lord, need not be, my lord. Contempt petition, what my learned senior counsel just now submitted, my lord. The petitioner has to show the violation. I have shown the violation by producing the FIR before this honorable court. But this is the violation. It is registered, not registered, I was called, not called, doesn't matter, my lord.
So don't make this submission.
My lord, this is the coercive action, my lord, this is the knowledge, my lord, I have gathered from the client.
Put it on record, we will respond. Don't take us by surprise.
My lord, this is the FIR, my lord. I will, the other submission, my lord, the FIR is not registered, my lord, for the timing, if I pause for a moment on that aspect, my lord. The registration of the FIR and the lodging of the FIR, my lord, the subject matter of the contempt petition and the suit, my lord, for which the suit was filed, and the punishment and the allegation made by the returning officer, these are all interconnected. But when this court issued an order of injunction, but what I understand, what we understand, well, when an order of injunction is passed under Order 39, Rule 1 and 2, regarding any civil dispute, not to interfere with the land, it means not to do anything on the land, any business on the land. If I connect it with the land, my lord, suit land. If there is an injunction order passed by the honorable court restraining the other parties from interfering with the peaceful possession of the suit property, it means not to interfere. Here, I would not have filed the contempt petition had the allegation been different in the FIR. The allegations on which the FIR was lodged is the subject matter, is the allegation made during the time of election. And if it is so serious, why not in the year 2022 the FIR was lodged? And why the police officer is not taking any action on the basis of the FIR? Well, the submission, I have, my lord, the contempt petition, it is suffice to show before this honorable court, some action has been taken by the authorities just to circumvent the order passed by this honorable court. And the coercive action means lodging anything with regard to the subject matter.
All right.
If it is subject matter, if the subject matter is suit property is a land, then with regard to the land. If it is with regard to the allegation, it is with regard to the allegation, the subject matter.
Okay, okay. All right.
That's my humble submission.
Item number given,
16.
Our learned counsel, Mr.
As Biswas.
S. Biswas for the petitioner. Learned senior counsel, Mr. A. M. Bora for respondent number 1, 2, and 3. Learned senior counsel, Mr. I. Chaudhary for respondent number 4, 5, and 6.
4, 5, and 6.
Anybody else? No, no?
Yes.
Only 4, 6 respondents. Please this matter. It will come up in the orders column. I'll prepare the order.
Yes.
It was in the orders column. It will come up in the order column. You want a date? Date?
I'll leave it to your lord.
As your lordship.
Date का ये और लंबा के 26 में भारत order ऐसे करते हैं आदि की डेट 26 में
March over.
All right.
This matter, Lordship, the engaged counsel A.Y. Chaudhary is hospitalized. He's not keeping well, and I received a file this morning only. So I
have no objection, my lord. But I should have been informed earlier, my lord.
No, Lordship.
Yes, yes. He's sitting the entire day since
No,
morning.
I informed him that
Why didn't you inform him? You're sitting near nearby. You should have informed him.
Actually, I did not know that my learned senior friend shall appear in this case. And the moment I thought that he will be appearing, then I informed him.
Item number 19.
Yes, Lord.
Learned Counsel, Mr.
R. Soma, Lord.
R. Soma has submitted that his senior, Mr.
A.Y. Chaudhary.
A.Y.
Chaudhary.
Chaudhary representing the appellant is not well.
Yes, Lord. He is hospitalized.
Learned Counsel, Mr.
NC Das, my lord, NC Das.
NC Das is present for the respondent number 1, 2, 3, and 4. List this matter on. You want a date?
In the next set, Lord. Next week. In the next week, I shall myself do the matter, Lord. But today I was not prepared.
Is this matter after 1 week?
Obliged. Lordship, insurance company, Lordship, challenge my quantum of award. I have filed for enhancement. So, Lordship, both the matters may be heard together.
Okay. Do we have time for hearing today?
No, other.
This is for orders, no?
Yes.
Okay. Okay. We have, everything is admitted and we have the LCR and everything?
Yes.
Hearings are complete?
No, Lordship,
LCR note.
in the main appeal, Lordship, may kindly see office note dated.
So we'll call for a LCR then.
Lordship.
Huh?
Lordship.
We don't have the LCR.
No, right now not yet received.
And for respondent number 3 and 4, Lordship, I need to take first steps on proper address
Okay.
in the main appeal.
All right. So we are taking up item number 19 and 20, 20 and 21.
No, 20, only.
Only
Only
20.
20. Okay. Learned Counsel, Mr. A.T. Sarkar is present for the appellant. Learned Counsel, Mr.
R. Sharma, Lordship.
R. Sharma is present for the insurer.
Insurance company.
Respondent number,
In the cross objection.
sole respondent.
Cross objection.
Maybe
I have
one.
not served the copy, Lordship, that's one. For respondent number 1.
One.
Hmm?
One, Lordship.
Respondent number 1. This is CO.
See.
It is CO লিখিবা CO 17 of 2024. We have the original appeal.
Lordship. In the appeal, I'm the appellant, Lordship.
Appeal to লগতে লিখি দিবা. Which is the appeal?
Appeal, Lordship, 450 of 2024.
MAC appeal 450 of 2024. The appellant is present and represented by Mr. R. Sharma, no?
Lordship.
The respondent, Mr. Learned Counsel for the respondent, Mr. A.T. Sarkar is present. This will be the claimant.
Yes.
Claimant,
Any
respondent number 1 and 2.
respondents?
Respondent number 3 and 4, Lordship, I need to take steps on proper address.
Okay, the Learned Counsel for the insurer has submitted that he will take fresh steps to issue notice to respondent number
3 and 4.
3 and 4 through their proper address. List the matter after 4 weeks.
Lordship.
Steps may be taken for service of notice returnable within 4 weeks.
Lovely, Lordship.
Item 21.
Mr. Jordan, I am appearing on behalf of the appellant. LCR has been received and notice has been served as per office note dated 5/5.
Only sole respondent, one respondent.
I appear for respondent
Yes,
number
no,
one.
Respondent number 2, I think, has not appeared
Received.
despite service.
Okay,
So matter ready as regards
we'll
service and
fix it for hearing.
Here,
They'll-
yes.
In meanwhile, they will arrive. And we have the LCR.
LCR is here.
Learned Counsel, Miss
Mona Lisa Borua Bhuya. M. Borua Bhuya.
M. Borua
Bhuya.
Bhuya. M. Borua Bhuya is present for the
Appellant.
appellant. Learned Counsel, Mr. D. Chakraborty is present for respondent number 1. Notices has been served to respondent number 2 and 3.
Yes, that is what is there in the office note.
As per office note 5/5/25. Notice has been served. As per note dated 5/5/25.
Office note dated 5/5/2025 indicates that
Notice has been served.
Though it does not indicate the respondent number, but it just says that.
notice has been served. Okay. List this, LCR has been received. List this matter for hearing. Yes. Should I fix a date, time frame?
Well, it's the first step, it can come in usual course.
Okay.
Item 22.
Your Honor, certain changes in the nature and character of the case has appeared during the pendency of the case. And I've been instructed to withdraw this case and with a liberty to appear before the lower court and file appropriate application. And if the requisite reliefs are not granted, we may be allowed to appear before this court.
Two liberties.
Only one liberty.
Learned Counsel, Mr.
G. Kaushik.
G. Kaushik is present for their appellant and has submitted that there are certain changes in circumstances and the appellant prefers to withdraw this appeal with a liberty to file a petition before the trial court. Trial court. Okay. Which is allowed. Matter stands closed.
Obliged.
I have লগতে লিখি দিবা লগতে লিখি দিবা
Item 23.
Yes.
May I please, your lordship? Your lordship, this appeal has been prepared by the insurance company.
You are doing
And for
claimant.
respondent number, yes, claimant. So for services concerned, only in respect of 6, who happens to be the driver of the offending vehicle.
not served.
Your
Respondent
lordship,
number
so
6
far,
not served.
so far driver is concerned, he is not a necessary party.
True.
And the delay is only 26 days.
Mhm.
So in that case, I have no objection if the delay is controlled.
Will condemn the delay, then he has no objection. Heard learned counsel, Mr.
Yes, Pegu.
S.
Pegu.
Pegu for the applicant who has filed his application under section 5 of the Limitation Act 1963 with prayer for condemnation of delay of 26 days. The learned counsel, Mr.
D. Mondo,
D. Mondal is present for the respondent number
1, 2, and 3.
1, 2, and 3. Full stop. Not 4. Same family.
4 expired.
4 has passed away. Okay.
5 is served.
1, 2, and 3. The respondent number 5 and 6 are not represented today. The delay is relating to 26. The petition is relating to delay of condonation of delay of 26 days. It is submitted that the petitioner has that the applicant has a good case.
Paragraph 4 will go there.
So the delay was the result of the delay was not intentional. Delay was not intentional and there was no negligence on the part of the applicant due to the formalities. You are the insurer, no?
Right.
Relating to the communication of the judgment and vetting, communication of the judgment and the order impugned by the applicant to the insurer and reply from the insurer, there arose a delay of 26 days. The learned counsel for the respondent says no objection. Thereby, delay is condoned. Raised to restore the connected appeal.
Your lordship, my name may be reflected at the time of listing of the.
Okay,
I see.
okay, the learned and to reflect the name of learned counsel, Mr. D. Mondal, in the cause list.
In the quarterly file, listing it for admission.
While listing it for
Admission.
it will come for admission, okay.
Obliged.
Item 24.
May it please your lordship.
Mm.
My lord, this is an application for refund of statutory amount, lordship. Which was deposited before the registry of this honorable court while filing the MSc appeal number 114/2013, lordship. And this appeal was already disposed of by order dated 28/2/19. So lordship.
Only
might
the
be-
statutory amount is not refunded.
Not yet refunded.
Appeal has been disposed of.
Yes, lordship. Therefore, this is an petition for refund of the statutory, which is
You are the
lying before the
insurer.
registry. Yes, lordship.
You are the insurer.
Yes.
You'll take back the statutory.
Yes,
amount.
lordship.
Learned Counsel Miss
M. Chaudhary.
M. Chaudhary is present for the insurer and has submitted this application for withdrawing the statutory amount deposited by the applicant,
Appellant.
appellant at the before the registry of this court. So it is submitted that the MSc appeal number 114
Yes, lordship.
of 2013 has already been disposed of
By order dated 28/2/19.
by order dated 28/2019.
Yes.
The petitioner's applicant's prayer to withdraw the refund amount is hereby allowed.
Lordship.
Withdraw the refund amount from
In
the
favor of the yes.
registry is hereby allowed.
To the appellant insurance company.
Sorry?
To the petitioner
yes.
insurance company. Must oblige, lordship. Disposed of, higher disposal. Higher
In
disposal.
terms of the above observation, I was disposed of.
Must oblige.
My lord, regarding service and report, my lord, case is ready for hearing, my lord. In the meantime, my lord, we have filed IA 2309/24, my lord. An application under order 41 rule 27. My lord, it may be heard at the time of hearing, my lord.
Okay, you want to give additional
I am in
evidence?
item number 25, my lord.
Malad 25, I am appearing for the respondent,
Yeah,
claimant, my lord.
she's not pressing this matter now. Additional evidence, I think.
Yes.
She's not
Well,
pressing, so we will hear it together.
No, my lord, the additional evidence which they, my lord, sought to be filed, my lord.
Hmm.
Rather
You have
filed,
objection.
Yes, I have objection to that.
You'll submit your written objection or you will place your objection.
My lord, I will file, but let us have a copy. My lord, we did not receive any copy of the IA, my lord, that they
They have
have
not
filed.
filed item, my lord.
My lord, a copy may kindly be
All right.
served on us
Okay.
so that we can file our written objection.
25 to 26, no?
The
I
primary
am only
objection.
25, my lord.
Huh?
I mean, item number 25, my lord.
Heard Learned Counsel Miss
L. Sharma.
L. Sharma.
Yes, ma'am.
For anybody.
जाते हो कहाँ तुम लोग?
Insurance, my lord. For
नहीं
appellant.
देती, कोर्ट में रहना चाहिए.
Miss L. Sharma.
Yes, ma'am.
For the insurance,
Yes, ma'am.
who has submitted that an interlocutory application under order 41 rule 27.
Lord, may I
has
submit
been
one
filed.
thing, Lord? May I
Learned
submit
Counsel?
one thing?
Yes, yes.
So
Yes,
far this IA is concerned, my lord. This is filed under order 41
rule
rule
27.
27 of CPC.
Of
Which is not,
CPC लिखी थी बारे.
which is not applicable in the instant case, my lord. With all respect, my lord.
This is
Because the-
first appeal or second appeal?
This
No,
is-
my lord, this is
this
MSc appeal,
This
ma'am.
is
MSc
MSc
appeal.
appeal.
Okay,
MSc appeal. However, CPC applies, my lord,
Yes.
as it appears. But here is a case your lordship will find. My lord, the company, insurance company, they did not contest the suit. My lord, they did not file written statement against the claim petition filed by the, my lord, claimant. Now, they wish to, my lord, adduce some evidence which is not their pleadings, my lord. Because the
That will
evidence,
decide, no?
Let them file objection, my lord.
my lord,
We
that will
decide.
be, my lord, otherwise had they been,
It may be heard at the time of hearing, my lord. No,
No,
no
not
problem,
at
my
the
lord.
time of
Yes, fine.
hearing.
no, not at the time of hearing. My lord. I'll file objection, then it will be heard, my lord.
We'll hear it before
Because-
hearing.
because-
There's a question of admitting also.
My lord, because if there is no pleadings, my lord, how can they adduce their evidence?
That is my,
Let them file objection, my lord.
File your objection,
Yes,
we
sir.
will decide.
All right.
Heard learned counsel Mr. BK Sen, who has submitted that he will file objection against the petition. List the matter after 2 weeks.
Yes, my lord.
I'm obliged.
26 May.
My lord, in 26, my lord, I am for the appellant.
Hmm.
Here, my lord, we have filed the cross appeal for, my lord, this enhancement.
Hmm.
Enhancement of the amount that has been passed by the learned.
Same case.
My lord, same judgment. my
26 to লিখি দিবা একেলগে লিখি দিবা
lord. So it
নাম
may be-
খিনি হেৰি কৰি দিবা ইন্টাৰচেঞ্জ কৰি দিবা learned counsel Mr. BK Sen is present and has filed a cross appeal against the judgment and order dated.
My lord, it's here.
এইটো ইয়াতে আছে নেকি ইয়াতে
Six.
ওলাই যাব ইয়াতে ওলাই যাব।
60 MSC case number 68 of 2018, my lord.
And date?
Date is 27/12/2018.
লিখিলা case number লিখিলা so now
It may be fixed for hearing, my lord.
then it will be separated, no?
Yes.
We'll list the matter for when it will come up for hearing, it will be separated because the other case I have not fixed for hearing.
Yes.
And it is better for you only. I have not fixed for you because on the date of hearing, they will submit the memo, that additional evidence
Yes.
to your disadvantage.
Yes, ma'am.
List the matter after 2 weeks.
Well, this case may be separated, my lord.
You want this case to be separated?
Yes.
Why? It is out of the same cause of action, isn't it?
All right, my lord, then we have to take. Obliged.
My lord, I'm for respondent, my lord. In this case, my lord, they have filed one IA, my lord, for stay, my lord. We have no problem, my lord, if stay is granted.
Okay. We'll stay there.
Put that.
Her learned counsel Miss IA number 2665 of 24.
Yes, 267 number, and one is 2666/20.
Her learned counsel Miss M. Khatun.
S. Burman.
S. Bormon. And you,
H here.
learned counsel Mr. H. Bhuya for the appellant.
For the appellant in the item number 31, but respondent in item number 30.
My lord, same judgment has been challenged.
Same judgment.
Okay.
Same judgment has been challenged by both of them.
And learned counsel
I
Mr.
should remember.
I. Chaudhary for the respondent. The applicants have filed this application under order 41 rule 5 read with section 151 CPC praying for stay of the judgment and decree dated 10/11/2010 passed by the civil judge junior division number 2 Kamrup M. This is RSA, isn't it?
This is RSA.
In title suit number 933 of 2006 and the judgment and order dated
10/11/2000.
10/11.
no, this is not 10/11. The title appeal.
Title appeal actually, my lord, there was a delay. They delay in preparing the title appeal. So that delay petition was not condoned. Delay was not condoned in title appeal.
Okay. So that title appeal has not been registered.
No, title appeal was registered, but the delay part was not condoned actually.
Okay.
The main appeal was.
So what is the judgment and order dated in title appeal?
Main results.
Judgment no hobo, order dated hobo.
28/24.
28/2024.
28 of 2024 in TA number?
It will be actually Miss J case
Miss
number.
appeal.
In Miss J case number. In Miss appeal number?
Miss J case
Miss-
number 177 of 2012.
In Miss J case number.
177.
You are challenging this, no?
Yes, challenging.
We are challenging. Earlier, there was order passed
by this honorable court
Mm.
that the mid-say is not necessary to stay. It is the learned court civil the junior judge order
Junior division number
10, 11, 10, 2010
10.
that may be stayed
11/10/2010
10
for stay of all সেইটো এৰিবাকে লিখি দিয়া যাব।
That will do.
for a stay of judgment and decree.
বাকীখিনি নালাগে stay of
ঠিক
judgment and decree dated civil judge junior division. The learned counsel for the respondent has no objection. It is submitted that the appellant may suffer irreparable loss if the aforementioned judgment and decree is not stayed by this court, as the order has been erroneously passed by the trial court. It is submitted that the applicant has good grounds and his appeal is likely to succeed. Considering the submissions at the bar, the judgment and decree dated 10/11/2010 passed by the learned civil judge junior division number 2 Kamrup in TS number 933 of 2006 is stayed till further orders. Not till the next date, till further orders, okay?
And the main case will be fixed for him. As LCR has received.
In terms of the above observation, the IS stands disposed of. RSA to fix us any RSA to liquid you list this matter for hearing. You want a date?
Yes. Preferably date matter.
Okay. You want a date?
Yes, madam. Date is required actually. They have filed this in the 2015. It is almost 10
List this
years.
matter for hearing or date. 3rd June.
3rd June, I will obey, my lord.
My lord, I have problem. I am suffering from stroke. Hence, I want at least 1 month.
Okay.
I am not fit for attend the court, but somehow I have appeared.
ECMA DVL.
Madam, then 18 June, madam.
18 June.
18 June. 17 June, okay, 17
Last
June.
part of the June.
17
Last
June.
part of the
24th of
yes.
24th of June.
Yes.
Obliged.
There's one other I in item 31.
No, 31 is the same. They also want
31,
to-
I am, the respondent is
Oh,
appellant in the 31.
acha. 31 or ekharo naam to likhi diba.
MDH, who is
Same
the
case,
petitioner.
Same.
Abul Kalam. Petitioner is the Abul Kalam and advocate is MDH, who are.
Petitioner kijon different হয়. All right. এজন দুজন বেলেগ দুটা ডিসপোজেবল একেটাই হয় ষ্টে কৰিবলৈ আছে চেক কৰি ল'বাচোন আৰু এবাৰ
May it please the Lordship. Lordship, we have filed this IA for withdrawal of the statutory deposit, which we had deposited at the time of filing of this appeal. And the appeal was disposed of on 19/4/2024.
একেটা অৰ্ডাৰ লিখি দিবা সেই ৰিফাণ্ড টু যে ষ্টেটুটৰী ডিপজিটটো একেটা অৰ্ডাৰ লিখি দিবা what is your name
M. Saikia, Lordship.
appeal number title appeal number MAC appeal number
MAC appeal number 235 of 23.
was disposed of on
19/4/24.
okay
Obliged, Lordship.
এই যে এটা ৰিফাণ্ড এমাউণ্ট যদি একে ধৰণে লিখি ষ্টেটুটৰী ডিপজিট বুলি লিখি দিলে হৈ যাব
Item 33.
Applicant is not represented for the interest of justice, list the matter after 2 weeks.
My lord, I'm paying for 2 weeks' time, my lord.
Learned Counsel, Miss
L Wajida, madam.
L. Wajida, with the consent of the other side, has prayed for adjournment, list the matter after 2 weeks.
Oblige.
To the lordship.
Hmm.
Question is the service on respondent 5 and 6 is not complete, but they are not necessary also.
Hmm.
They can be struck off. also. And the delay of 8 days, lordship, that may be considered. 9 days.
Learned Counsel, Mr. P. Bothakur, for the applicant has submitted that. The
I'll go
respondent
submit.
number 4, huh?
I'll go submit.
Al Goswami, sorry. Al Goswami has submitted that the respondent number 4 and 5.
No, lordship, 5 and 6.
Respondent number 5 and 6 are not necessary parties, and their names can be struck off, full stop accordingly. Names of respondent number 5 and 6 has been struck off from the area of parties. Learned Counsel, Mr. A.K. Gupta is present for the respondent number 1,
1 to 4, man.
1 to 4. Heard Learned Counsel, heard both the sides. This is an application under section 5 of the Limitation Act 1963 with prayer for condonation of delay of 5 days. 5 days,
8 days, lordship.
8 days. It is submitted that there was no willful negligence on the part of the insurance company except for certain procedural formalities to stop. I've considered the submissions at the bar. Delay is hereby condoned. Registry to register the connected appeal.
Lordship, can it come on Monday, lordship?
Connected
This-
appeal.
Monday, it's a little urgent first.
No,
Yes, sir.
no, it has to be registered, then only we can fix
That's
it.
right. After registration, it can come on Monday if they fix it is given. Or Wednesday next. Because they are already proceeding for execution.
What execution? This is not a McAfee.
It's a matter of lordship.
Whatever
If it comes on
execution,
Wednesday, lordship,
whatever execution in McAfee.
for non-realization of the award decree. lordship. It's already there, my friend, Leonard friend knows about it.
They have not,
That's why
they have not paid the awarded amount, that's why the execution is filed.
So,
Okay.
if it comes on Wednesday, it
That
will help.
long procedure, baki jai.
No, lordship, what has happened, they have filed it under
I know
order
there's a
21,
section-
22. So it's a little faster than baki jai. If it comes on Wednesday, lordship, that will help.
On Wednesday,
Wednesday. Obliged.
I used to register this appeal and list it out. Wednesday, date of the litigation. As the
20.
matter is urgent.
Obliged.
As it is submitted that the matter is urgent, as it is submitted by the learned counsel for the insurer, that the matter is urgent.
Obliged.
My lord, I am appearing for OP number 2, my lord,
Hmm.
in the IA. And in that case, my lord, we have filed our objection, which is already on record, my lord. I am also the decree holder, my lord. Actually, this IA has been filed by some stranger, my lord. They want to implicate themselves in the appeal, who is not a party to our,
But they are not present today.
not present, my lord. In the interest of justice, my lord, one chance may be given and the date may be fixed.
Applicant is not represented today. The learned counsel, Mr.
B. Burwa,
B. Vora is present for the respondent.
OP number 2 in the IA.
For
Opposite
the
party
respondent number 2. And learned counsel, Mr. Learned counsel, Mr. S. Dutta is present for OP number 1. List this, for the interest of justice, list this matter after 1 week, 2 weeks? 2 weeks,
Week, no, date may be fixed.
3 weeks?
2 weeks, man.
Huh?
2 weeks.
2 weeks, 2 weeks.
Date may be fixed, my lord, because RFA is
Date
of
is the due.
2018, my lord. Obliged.
Very the lordship. I mean, it's a regular first appeal matter. It should come in the admission matter, come in the order matter. It can be admitted matter. Because the caveator, they've already appeared last date matter. Now notice is to be served actually.
We'll fix it for admission. We have a caveator. We'll have to hear the caveator.
No, they appeared last time, in fact.
They appeared.
Last time they appeared, their name shown, my lord. It came up.
2025.
They appeared when time was taken, my lord.
We'll list it for admission.
Ma-
We'll admit it.
Yes, yes.
Secretary appeal will have
Yes,
to admit
statutory
it.
will stay is also necessary, but then, it may be fixed, Monday or something like that.
Monday?
Yes, yes.
Learned Counsel, Mr. B. Hazarika is present. for the-
Chaudhary, my lord, A. Chaudhary.
Huh?
My name is A. Chaudhary.
A. Chaudhary is present for the appellant. The respondents are not present today. This is the matter for admission
Monday.
On Monday, my lord.
on 19. Monday 19 হয় না? On
Obliged.
19.
Please.
With regard to respondent number 2, 3, and 4, the service is complete, my lord. And respondent number 1, service is awaited, my lord. My lord, let the matter be fixed after 2 weeks, my lord.
Service report on respondent number, which one?
2, 3, and 4 completed, my lord. Service is awaited upon respondent number 1.
On respondent number 1 is awaited. Service report on respondent number 1 is awaited. List the matter after 2 weeks.
2 weeks, my lord. Yeah, date may be fixed, my lord. 28th, my lord.
List the matter on. Okay.
Much obliged.
28. Item 39.
My dear Lordship. Lordship, there's an application for substitution. Which the respondent number 1, he died. And the respondent number 1 died. There is IN number 1091, Lordship. 1091, there is a delay of 130 days. The copy has already been served to the existing advocates. So they're representing the respondent number 1 and respondent number 2. So respondent number 1 died, they have not informed it. So that is why we had no knowledge about it. Even then we made attempt and we got the information from his neighbors. Then we, from the date of this 130 days delay, and they have not filed the objection against that. Delay may be condoned, your lordship, and the notice may be issued to the legal heirs of the respondent number 1.
130 days, we will have to issue notice.
Lordship.
Applicant to take steps to issue notice to the respondent. Respondent or respondents?
Respondents.
Respondents.
And substituted legal heirs, the legal heirs.
Ah.
Legal heirs.
And the substituted, already substituted.
No, they are not substituted.
Okay.
The respondent number 1 died. They are legal heirs number 1 and 2.
No.
But
They
the
are not
other
substituted, no?
persons.
Respondents are लिखी दिया.
Yes, ma'am.
List the matter after 2 weeks.
May I please proceed? No, sir, file a miscase for restoration of RSA number 4 of 2010, but there's a delay of 296 days.
You'll
Your
issue
notice will be issued to respondents.
Applicant to take steps to issue notice to the respondents.
Number 1 and 2.
Respondents number 1 and 2. List the matter on after 2 weeks.
Yes, sir.
After 2 weeks.
Obliged.
Item 41.
May it please, your lordship. My lord, this IA Civil 1224 of 2025 in second appeal number 146 of 2017 has been registered upon a joint petition filed by both the parties for a compromise decree, praying for a compromise decree under Order 23 Rule 3, my lord. The parties have settled amicably the dispute with several terms and conditions. And in view of that has been placed before lordship, that compromise agreement and supported by affidavit by both the parties sworn together. So in view of that, your lordship may please to pass a decree, compromise decree in RSA number 146 of 2017.
My respect to Baidu. This is called orthodox civil lawyer. This type of complicated matter come to an end.
to pass the
No,
order.
my
It is because of Baidu, it is possible, otherwise not.
RSA compromise.
There's something unheard of.
First
Anyway,
appeal,
no,
it's difficult to compromise. You
yes,
compromise in
very
second
good. So,
appeal.
so anyway, it's matter.
Where is
You
the
can see the page 6 of the application lawsuit. That is the small pair. Baidu has said that the compromise agreement treating the terms and condition of the deed of compromise, that is annex lawsuit.
So, concurrent decisions.
Lawsuit,
Concurrent-
both the parties have
Then
website.
merge the decree.
Yes.
The earlier degrees.
Yes,
But-
these annexer 1
Hmm.
to be made part of the decree lawsuit.
Okay,
That is the prayer lawsuit.
That
So
is-
both the parties have signed and
okay.
That is the prayer.
all credit goes to
Represented by
Baidu.
senior lawyers. Where is my problem?
My senior, in age very much junior, but senior. So he has made a submission eulogizing me. I do not think I deserve.
No.
Yes, you deserve. Why not?
From the when
RSA.
from
you
my
have set
from
up
my day of
affidavit.
joining, I have seen Baidu.
Your eulogies.
Thank you
That
so
is,
much.
that is great. Otherwise, it is not possible.
Learned counsel Miss
B. Chaudhary.
B. Chaudhary, senior counsel.
No, my lord, I am
Miss B.
junior.
Chaudhary for the appellant Roman Sharma is present. Learned senior counsel Mr. S. Sharma is present for the respondent. Syamol
Shyamol Sharma.
Sharma, who was the plaintiff who brought up the title suit number.
It is the arising 104/06.
104/2006 against the respondent. Now an interlocutory application has been filed by both the parties jointly under Order 23, Rule C of the Code of Civil Procedure 1908 within bracket CPC for short.
The parties have signed the agreement dated 3/3/25 compromise, deed of compromise dated 3/3/25, and that has been made a part of this application.
The applicants are the appellants of RSA number 146 of 2017.
Yes.
2017, yes.
Who have preferred the appeal against the aforementioned title suit?
Yeah,
We
no,
have
my
just
lord.
mentioned.
Title suit was dismissed, then appeal was preferred by the plaintiff
yes.
and the title suit, the appeal was also dismissed, then, no, appeal was
Allowed.
not allowed, my lord. And against that, we preferred the second appeal. And
Now, lawsuit will not go to all these detailed lawsuit because
No,
this
no,
is
I'll
joint-
just mention the names.
Yes.
The applicants of this case are Sri Abhijit Sharma. They are the applicants, no?
Yes.
yes,
Srimati
heirs of the original
Meera Sharma,
appellant.
Srimati Sweetie Sharma,
Hmm.
son being son, wife and daughter
Yes,
of whose?
of
Roman
Roman Sharma,
Of Roman Sharma.
the original appellant of before this court, no, Jana?
Original,
Original appellant
died.
before this court.
and the respondent to nalage, ঠিক আছে। Along with লিখি দে, along with Sri Syamol Sharma.
Because it's a joint affidavit at page 7.
The applicants have filed a joint affidavit both the parties have amicably settled their dispute and the terms and conditions of the dispute are very well described in the joint affidavit?
No, my
You know,
lord.
in the deed of compromise.
Annexure 1.
Deed of
In the deed of compromise marked as annexure, very well described in the very well uh, terms and conditions of the
Settlement.
settlement have been described in the deed of compromise marked as annexure 1 of the application. This annexure 1 is marked as X. So highlighted points for any highlighting
No, my lord.
points to be
The
highlighted.
whole annexure, the agreement will be a part of the decree.
Decree.
This deed of
The
compromise will be
Second appeal close as per the compromise decree, and this deed may be a part of the decree. That is the prayer, my lord.
okay, this
They-
deed of compromise will be a part of the decree of the RSA number 146 of 2017.
Yes.
Where is the prayer?
Lordship at page 6. It started at page 5 last year, last part.
I have considered the submissions at the bar with circumspection. I have scrutinized the affidavit and the annexure 1 of the application, which is admitted.
The second appeal is decreed on compromise,
Yes, yes.
and the decree be
In
prepared.
the wake of the foregoing discussions, this second appeal is decreed on compromise, and the annexure and the annexure 1 marked as X will form a part of the decree, which will be merged with the earlier decree. Okay.
Annexure 1 to the IA, my lord. Annexure 1 to the IA.
Or need not be merged, I think.
No, no.
Merger of decrees will be
The merger of decree is there.
automatically.
No, the earlier decree, no. Lordship will say that this compromise
Yeah.
decree, I have specifically stated that paragraph 6, Lordship.
Yes.
This is not a first appeal to form a merger of decrees.
No.
So-
It's a second appeal. Arrest. So this paragraph 6 is the clear line, Lordship, that it is this compromise decree, treating as the terms and condition of the deed of compromise.
I'll tweak it. We'll make it
Lordship.
more appropriate
Lordship,
later.
Lordship.
In terms of the above observation, the RSA number 146 of 2017 is hereby disposed of.
And the IA number 1224 of. The IA is to be disposed of.
Oh, no. RSA number as well as the IA number of. IA number 1224 of 2025 and the RSA number 146 of 2014 is hereby disposed of.
Last line, draw a decree accordingly.
Should I prepare a merger decree?
No,
No, draw a decree accordingly.
Draw a decree accordingly.
Draw a decree accordingly. Yes, thank you for helping me out.
LCR to be sent back, Los.
Oh, yes, yes.
LCR to be
Thank
sent.
you so much for helping me out. Send back the trial court records.
I'm
Item number 56, my lord, it was an IA for stay of the judgment, my lord, interim judgment. Let the matter may come up on 28, my lord. Item number 50.
Is the matter on 28?
56, my lord.
Item number 56, yes.
Oblige, my lord.
May I please the lordship?
Item 56.
I have a single prayer in respect of item number 46, lordship. This is condonation of delay, lordship. Only notice may be issued, lordship.
Item number
46.
46. Applicant to issue notice to the respondent. List the matter after 2 weeks. Item number 45, same, my lord. Item number 45 also. Same one.
Lordship, I'm accepting notice on behalf of respondent number 1 to 3, your lordship. Our date may be fixed in 45.
Which one?
Item number 45.
45.
The gentle lady just gave this item number.
Issue
55.
notice.
Issue notice.
Okay.
A date may be fixed.
Release the matter on date of the release, item number 45.
Pleasure.
Lordship, item number 48,
Hmm.
delay condonation petition, notice may be issued.
Item number 48.
48,
Ah.
steps by both ways, registered post as well as visual process.
Okay, issue notice to the respondents
Lordship,
through registered post as well as usual process,
Lordship,
returnable within 4 weeks,
Lordship.
list accordingly.
Item number 43, Lordship, we have filed for releasing of a check which has been deposited by the insurance company, Lord.
Sorry,
Amount deposited pursuant to the court's order, Lord. And we have filed 43 for releasing of a check, Lordship.
releasing of the check.
Yes.
43.
I have for the insurance company in this.
Huh?
Insurance. He is
I'm
the
for the
insurance.
insurance.
Should I fix a date or should I pass an order today?
Yes.
Today.
Lordship, I have no objection regarding release, but Lordship,
43.
I,
Third learners, Council Mr. A.T. Sarkar, who has filed this application under section, not under section, who has filed this application with prayer for releasing the check amounting to rupees 6,63,827 to the applicant stroke respondent number 1 deposited by the appellant pursuant to the order dated 21/1/2025 passed by this court in IA number 4043 of 2024 arising out of MAC appeal number 323 of 2024.
MSC appeal.
MAC appeal.
Oh,
MEC.
sorry.
MAC appeal, MAC appeal. I
Sorry, sorry.
don't worry. He will write as MAC only, not MAT. Hard learned counsel, Mr.
SP Sharma, Lordship.
SP Sharma for the insurer who has no objection.
But Lordship, I have one prayer, Lordship.
Hmm.
Regarding release, I have no objection, but they can furnish a bond if Lordship allows.
Under the condition that the applicant furnishes, executes a bond to the satisfaction of the registry of this court.
Lordship.
Full stop. Thereby, the respondent insurer is directed to release the amount within 2 weeks from today.
Lordship,
Not
3
already.
weeks.
Huh?
Already deposit.
Already deposited.
Already deposited. Nalaga, ito kati dia. Okay.
Hello.
In terms of the above observation, I.
Lordship, in the
accept this
main
full stop.
appeal, LCR may be called for also. Reminder may be
Appeal
sent.
to Likhasan, make appeal to call for the trial court records.
Obliged.
List after 2 weeks.
But item number 47, madam, delay condonation petition, madam,
Hmm.
notice may be issued, madam. Notice may be issued, madam, delay of 121 days, madam,
47, no?
47,
Issue notice to the respondents, returnable within 4 weeks.
yes. Yes, but only one thing, madam, in paragraph 5, inadvertently, my lord, 127 days was mentioned, can you correct it, madam?
No.
Amendments, then, my lord, leave.
You file an amendment petition. Earlier, it was very easy.
Yes, yes.
হৈ গ'ল নেকি? Leftover আছে নেকি? Hearing আছিল নেকি আজি? আহিছিলে নেকি?
They were there, Lordship.
So sad. Orders took such a long time than hearing.